Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
That was getting commentary on the case. That him, he Anglican for he's very sloppy. Oh, for crumb's sake. I didn't ask you to interrupt me.
Good morning, good morning, good Monday morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Good to have you all here this morning. Happy Monday. How was your weekend? I'm waiting for your answers. How was your weekend? Let's see. Amber, well, first, let me do this. Jennifer, let me first get this will work. How about that? I knew I was skipping a step. And of course, it doesn't want to work this morning. So I'm on the wrong network. Onto the right network.
Alex stole it.
Maybe it'll work. There we go. Okay, Jennifer Juniper, first in chat this morning. Congratulations. A little bit of pause there for dramatic effect. Jennifer, yes. Welcome. Thank you very much for being first in chat. You were first, and that means that we are going to send it to you with internet ownership. All the internet doth belong to you. I hereby bequeath it unto you, as far as I am able. So for today, it's going to be a thing. Yeah, the chat wasn't on the screen because my box was not connected to my computer. I needed to do that. Just cables and connections and stuff. Let's see. Oh, how was your weekend? I was asking. Jen's totally dancing in her chair. Nice. Island's Princess. It was terrible. I've been sick and I've had a cough since April.
I saw a chicken fight.
You did that over the weekend? I was in the doctor's this morning. I am sorry, Island's Princess. Get feeling better.
Shame on you, sir.
Get feeling better. Shame on you. I'll turn those down just a little bit. Those are loud today. I don't know why. All right, fun. We had both of you on Saturday. We did. Oh my goodness, Saturday was a surprise. If you didn't watch Saturday, there's what we did was we went over Sarah Boon's newest letter. Yes, she has another letter, and probably the most interesting part. If I show you here this right now, is that after her, thank you, I shall return, nothing's impossible, closing, she had a full-page ad, inmate seeks attorney looking for a prosperous challenge, ready for your close-up on national television. Are you zealous with the sight of keen? Show the world who you are with your original creativity, extraordinary expertise, confident ingenuity. Qualifications must include with 2 arrows, so that means a must. Being trustworthy, honest, passion-driven, open-minded, exceptional problem-solving skills, client inclusion at all times, team orientation, collaboration, extreme efficiency in listening, communicating, understanding, dedication to success, possessing a winning mindset, capability of excellence in representation, committed, maintaining faith in the client and case with the ability to think differently and overcome all circumstances. Epic opportunity awaits. Just contact Sarah Boon at inmate number 2000. 5623, Orange County Corrections Department. Invest in the oppressed, believe. Wow. I still am blown away by that letter. Honestly, it was a lot. And honestly, she does a better job designing and laying out a full-page ad than I ever could. I kid you not. I have zero artistic ability when it comes. You've seen me try to make thumbnails. They're not very good, right? She's got a gift where I do not. So, yes, she definitely gets an A+ for creativity. She needs an attorney to respond immediately because the deadline for filings, I believe, are today. All filings, yeah. It's Yeah, get right on that if you're going to jump on that opportunity. All right, we've got a couple people to celebrate birthdays with, and then we're going to start and talk about what's happening today and what we're following and how we're going to follow it, which is still sort of up in the air, honestly, because we've got, I think, jury selection happening, but we'll see. Maybe they've selected the jury already. Have they selected the Ashley Benefield jury? I thought they did it already for some reason, but maybe it might still be today. You guys correct me. Either way, we're gonna get going on that case as it's moving forward, and I'll tell you why. Let's see. Birthdays today: Cheryl C, Rocky's 743, and Lillers Nevrin. Lillers Nevrin. Is that right? That's how I'm gonna say it in the song. I think I'm gonna try anyway. So let's sing together to celebrate these wonderful three people and their these three wonderful people, I should say, and then they can start partying because they've been waiting all day they've been waiting all morning to start partying. So raise your voices with mine, blend them with your neighbors. Deep breath, shoulders back, project your voice to the back of the room. Let's warm up if we can. La 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 la. Here we go. Everybody sing with me. Dancers at the ready. Happy birthday to you. Happy birthday to you. Happy birthday, Cheryl C. Rocky 743 and Lillers Nevrin. Happy birthday to you. Lillers, your name tripped me up a little bit, but I hope that doesn't stop you from partying and celebrating all day long. Congratulations, Cheryl, Rockies, and Lillers. It's your special day today. It's not Burger King, but you can get pancakes. You can get pancakes at IHOP or Denny's or somewhere else that honors the time-honored tradition, which, I've got another one. And another verse. Okay. Happy birthday to you. Happy birthday to you. Happy birthday, dear Anne. Happy birthday to you. Candace. We need Candace. One more verse for Candace. This is the last time. Did I miss anybody else? Okay, we've got a Candace in here too. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Candace. Happy birthday to you. This is rare. This is extremely rare. It doesn't happen. It normally doesn't. We got the hat trick. Gordon, we got the hat trick of birthday songs. Candace, happy birthday. To all those celebrating their birthday today, Tash outed you, I guess. Happy birthday. I hope we can make your day. I hope we've already made your day a little bit more special. With all the singing and dancing and the partying that's going on, you can now blow out the candles, get your pancakes and everything else. Dedicated verse just for Candace and Anne. Anne and Candace, it was timed perfectly. Well, or terribly, depending on how you look at it. So, anyway, let's do a big drum roll finish for everybody. We'll wrap this up. Ready? There we go. I guess that's not really a drum roll. What's it called when you do the toms? Yeah. I don't know. If I was a drummer, I'd probably know that better what it was, but I'll go with drum roll for today. All right. It's just a big finish. That's all. Drum solo. That works, Jennifer. Drum solo. Happy birthday, everybody. That's super cool. Okay, I'm going to close down Sarah's letter. If you missed Sarah's letter, go back and watch it. Share it with a friend. We did it as a live stream on Saturday. I think we did it justice, and we had Mrs. R.A. with us we had her presence. We had her voice. We still don't have her on camera because my green screen is only this big, right? Let me see where it is. Helps if you guys can see that. My green screen is only that big. As a matter of fact, it's already off. There we go. That's how big the green screen is. So either I need a bigger green screen or another camera situation. Maybe you could set her up in another room. I mean, I've got enough equipment. I could do that. Forgot Prince George of Wales today. I think someone else is going to sing to him, Josh. Maybe the whole country. Michael Rogers, hi. Is this a new person? Thank you. A new case? Yes, the Ashley Benefield case is new. Let me start off and tell you what was happening. Let's see here. Let's see.
Have them send someone with more experience.
So let me get the document up that we need to talk about here. It's right over here. Boom, boom, boom. The Ashley Benefield case, for those that are interested, is a little bit crazy. It's got some funny things in it, and it's also got some history where it tried to go forward, and now we're back again, and now we're starting over again. So we're not going to focus on that. We're going to focus on this version of the trial and what was going on. If I can get my mouse to work. Oh, I got this one. My new mouse. There it is. All right. And it shall work for me. I'm calling it here. I'm just positive vibes out into the ether. All right. There we go. I feel like I'm missing something. Is there something? Hopefully jury selection won't take long. I think they've definitely got a lot of people to choose from. I mean, Florida is quite a populous place. Usually they bring in a large crowd. It's a big courthouse, so they can do that. They have the room to handle a huge list of people. We're gonna cover the emergency motion. We're covering that. Let me read it first, and because they're doing jury selection, we're gonna read it and then look at what the judge is gonna do. So let's just kick that off. Is that all right? Oops. Full screen. All right. This is State of Florida versus Ashley Benefield. This was a motion that was filed on 7/19. That puts it like Friday, right? Friday at 1 o'clock in the afternoon. Defendant's emergency motion for continuance. And as we know, in court terminology, continuing means stopping. Continuance means they want to continue the break before trial starts. It's a delay is what they're asking for. Ashley C. Benefield, by and through undersigned counsel, pursuant to Florida Rule of Criminal Procedure 3.11 or 190F, and the 6th and 14th Amendments to the United States Constitution. That's when they're really trying to bolster their argument. They say it's my right. And the due process provisions of Article 1, Section 9 of the Constitution of the State of Florida, and respectively moves this honorable court for a continuance of the trial scheduled to begin on July 22nd. That's today. In support thereof, Ms. Benefield states as follows. This case is currently set for trial on July 22nd. Ms. Benefield faces serious charges, including murder, which carry potential life-altering consequences. Recent rulings by this court have seriously impaired Ms. Benefield's ability to present an effective defense, violating her constitutional rights to a fair trial. To present a complete defense, to compulsory process for obtaining witnesses, and to the effective assistance of counsel. Given the gravity of the charges and the constitutional implications of the court's recent rulings, a continuance is not merely warranted, but absolutely necessary to safeguard Ms. Benefield's fundamental rights and the integrity of these proceedings. Why? Well, here's the background. On July 16th, a mere 3 business days before the scheduled trial date, the court denied the defense's request for, get this, paralegal Jack O'Keefe to remain at counsel table for trial. This denial was issued without providing any reasoning, leaving the defense team suddenly bereft of a crucial assistance on the eve of trial. On July 17th, defense counsel moved for a stay of the proceedings to enable the pursuit of a writ of certiorari to the 2nd District Court of Appeal regarding the court's order denying Mr. O'Keefe's presence at counsel table. This is the guy that has not passed the bar, and he wants to sit at the table, like the big kids' table, like a lawyer. The judge says it's a discretionary thing, and I say no. And so they're asking for a continuance. On July 19th, this court transmitted its order denying the defense's emergency request for a stay of proceedings. Compounding these issues on the eve of trial, this court issued an order granting motion to quash subpoena directed to Vicky Mechanic, a material defense witness whose testimony is crucial to presenting a complete defense, thereby undermining Ms. Benefield's constitutional right to call witnesses on her behalf, as provided in the 6th Amendment of the United States Constitution and Article 1, Section 16 of the Constitution of the State of Florida, further exacerbating The prejudice for Miss Benefield. On July 19th, the state emailed the court objecting to defense request for an HDMI connection for Mr. O'Keefe to connect his laptop to present the defense exhibits at trial. Now this, I'm with. I can get behind this one. This objection, if sustained, would severely hamper Mrs. Benefield's ability to efficiently and effectively present crucial evidence to the jury. The state's opposition to this standard trial practice is not only unreasonable, but appears calculated to further disadvantage the defense. This latest development, combined with the court's previous rulings, creates an insurmountable obstacle to Miss Benefield's right to a fair trial and her ability to present a complete defense. The cumulative effect of these restrictions on the defense team's resources and capabilities significantly impairs counsel's ability to provide an effective assistance, as guaranteed by the Sixth Amendment. Here's the legal argument. Good cause exists for granting a continuance. Florida Rule of Criminal Procedure 3.190F Part 2 provides that the court may grant a continuance in its discretion for good cause shown. The circumstances presented here not only constitute good cause, but demonstrate an urgent necessity for the continuance to protect Miss Benefield's constitutional rights. The Florida Supreme Court has held that the right to present evidence on one's own behalf is a fundamental right to our basic adversary system of criminal justice, and is a part of the due process of law that is guaranteed to defendants in state criminal courts by the 14th Amendment to the federal Constitution. And case citations. The court's order quashing the subpoena for Vicky Mechanic directly impinges on this fundamental right. As the United States Supreme Court reminds us, few rights are more fundamental than that of an accused to present witnesses in its own defense. According to the United States Supreme Court, the due process right of a defendant in a criminal trial is, in essence, the right to a fair opportunity to defend against the state's accusations. The rights to confront and cross-examine witnesses and to call witnesses in one's own behalf have long been recognized as essential to due process. Indeed, the right of an accused to present witnesses in his own defense is one of the most fundamental rights. Moreover, the Sixth Amendment right to counsel encompasses the right to reasonably necessary support staff at counsel so as to enable the effective assistance of counsel. Denial of a continuance will result in substantial prejudice. The sudden loss of Mr. O'Keefe's assistance and the exclusion of Vicky Mechanic's testimony mere days before trial will substantially prejudice the defendant's ability to present an effective defense. This prejudice is not harmless and strikes at the heart of Miss Benefield's constitutional rights. A continuance is necessary to protect Miss Benefield's constitutional rights. Whether rooted directly in the Due Process Clause of the 14th Amendment or the Compulsory Process or Confrontation Clauses of the 6th Amendment, the Constitution guarantees criminal defendants a meaningful opportunity to present a complete defense. The court's recent rulings have severely curtailed this right. Furthermore, the right to effective assistance of counsel, as guaranteed by the Sixth Amendment, is jeopardized when defense counsel is deprived of necessary support staff and key witnesses mere days before a complex murder trial. A continuance is necessary to allow Miss Benefield to pursue a writ of certiorari to the Second District Court of Appeal regarding the denial of Mr. O'Keefe's assistance at counsel table. Restructure of the defense's trial presentation without Mr. O'Keefe's assistance and determine an alternative method to present material evidence that was to be offered through Vicky Mechanic, a meaningful opportunity to present a complete defense and ensure that Miss Benefield's constitutional rights are adequately protected. In conclusion, wherefore, based on the foregoing, Miss Benefield respectfully requests this honorable court grant a continuance of the trial scheduled to begin July 22nd for a period of at least 60 days. That's how long they want the continuance. That's not how long the trial is going to take. For such time as the court deems appropriate to address issues outlined herein, and grant any other relief this court deems just and proper to ensure the protection of Miss Benefield's constitutional rights. Respectfully submitted, and it's signed by her attorney and herself. She signed it as well. That's nice. And then we've got a certificate of good faith. I hereby certify this motion for continuance is made in good faith and not for purposes of delay. That's the lawyer. Court's judicial requirements. The defendant is not in custody. The information indictment is filed on November 16th. The charge is second-degree murder. The parties have previously stipulated to continue case management conferences on 10 prior occasions. There have been no previous continuances of trial, once set by either party. Speedy trial has been waived. The defense has made all reasonable efforts to move the case and resolve discovery issues as they presented themselves. And then they submitted it to the court, and that's it. So that's the document that was filed on Friday that the judge had to handle first thing this morning. So let's look at that. Bring this over here, shall we? And do we have audio? I think we do. Give us just a second. I still don't have audio. Come on.
Motion. So, yeah.
Okay, we're just going to take it. So the audio starts here in just a second. We'll get it connected.
Services to extend the cable, but apparently not. So, yes.
There was no matter pending before me. There was a bunch of emails going back and forth, but I don't rule on emails, sir.
Judge, it's just so we're clear, it's my position. This is not an issue that should be dignified by a formal motion. Connecting my assistant's laptop to assist me in defending Miss Benefield and requiring a formal motion for something so perfunctory is an indication of just how difficult the court has sought to make this for the defense from day one. That's my position, Your Honor.
He just wants an HDMI cable.
So
I could send him one.
I haven't even been mentioned other than the fact my judicial assistant was copied on some emails going back and forth about this issue. Did you just expect me to jump in?
Yes, in fact, I did.
Okay, well, that would be inappropriate. So tell me where you want to run the cable from and what the problem is.
We need the laptop connected. As the court well knows, Mr. O'Keefe has not been permitted to sit at counsel table, so the cable needs to extend to this back bench for Mr. O'Keefe and court services.
To where?
Where?
To your table?
To the back bench. It needs to go past our table.
He's having issues. Let me see if I can bring it on a different feed. Now we lost the audio altogether. Anyway, this is the motion they're arguing. This was this morning, just moments ago. He's literally, they're fighting with the judge over an HDMI cable. So that Mr. O'Keefe, who's back there in the back right corner to Miss Benefield's left, will have his computer connected to the HDMI. He's filing a motion. He's making a motion in court for an HDMI cable, and apparently that's what the judge wanted. And while they figure this out, which I'm sure they will to some resolution or another, Mr. O'Keefe, just pass the bar, my friend. Pass the bar. You'll be good. Selena Carr gifted a membership this morning. Thank you very much, Selena. Alicia.
Case law and the rules is the unlicensed practice of law. If Mr. Taylor is talking about just having him turn it on, then that's a different story. But in the email, it was not clear. And so all I did, I emailed your JA to say, hey, can we talk about it Monday? So if it's just to hit the button because Mr. Taylor is incapable, then I would not have an objection.
Okay.
Thank you.
Yeah. Just run the cable. We'll get duct tape. In fact,
yeah,
duct tape.
And as the court knows, Mr. has never practiced law in Your Honor's court, so I don't quite understand the state's position, but he's going to hit the button.
All right. The great motion of the cable is resolved.
Thank you.
And we can move on to the...
Okay. Yeah, it's resolved. So he gets the cable. I'm sorry, that's just funny. The great motion of the cable. We need a cable on the thumbnail. Alicia, congratulations on 13 months. Kevin, good morning. Happy Monday to all. 17 months, Kevin, one of the OGs. And Amber as well, one of our great mods. Happy new trial day. No place I'd rather be. Love you all bunches. So we're
deprived of that assistance. So we would have to go back through a lot of our exhibits. And as I've articulated in our motion, the reasons why we think continuance is appropriate. That's our emergency motion to continue.
Thank you.
So they just argued that motion that we just read.
We object, and we find that there's no valid reason for a continuance.
All right. The question I have is, late last week, I don't know if it was Thursday or Friday, I received a motion. I don't know if I have it in my pile. Under 90.702, Daubert, for the defendant's expert. I don't remember his name, but it was referenced last week. So,
Ferris. Yes, sir.
all right. Typically, that would be heard prior to trial. Sufficient time for both sides to have a ruling and be prepared.
I understand, Judge, and that was a response really to what happened on Tuesday, because we thought we had handled it the appropriate way, and evidently we had not, and so I was trying to correct it. I did put in the motion that I understand it's normally a pretrial motion, but in order to not have Mr. Ferris have to come here and try to handle it this morning when we're trying to pick a jury, we have no objection to just having it basically Thursday, whatever morning he would be here, because the state has objections to his testimony on many grounds, and we have a fear that it's going to be a situation where we're have some kind of hearing when it's Your Honors thinks it's appropriate to discuss whether or not his expertise as a domestic violence expert qualifies him to testify during this trial.
All right.
And I'm sorry, sorry, Judge, I left out. Our other thought was some of it depends on what comes out during trial, and so it's kind of hard to handle it pre-trial. As we discussed last week, some of the other things are very difficult, and which is the other reason we thought it might be more appropriately heard right before he was going to testify.
All right.
Thank you, Judge.
The procedural hurdle that raises is going to be if I deny the state's Daubert challenge, or whatever the ruling may be, but it's against the state, you certainly have the right to appeal. And I think the problem would be if we're in the middle of trial and it's late this week or sometime early next week, the difficulties that could raise.
We understand, Judge. I think we're past that point. We're at the point of we're ready for this trial to go and to get it through. So
okay.
Thank you.
All right. Yes, sir. Any final thoughts?
Yeah. Well, as I raised earlier, not only did the court issue a cutoff date for motions, but both sides signed off on that cutoff date, and that cutoff date is long past. So this request for a Daubert hearing is beyond tardy, and I think the court should deny it. It's as simple as that.
Well, we'll cross that bridge when we come to it. I think both parties were filing motions and asking for hearing time well past the cutoff. All right, in considering the motion to continue, we start with although not sure all of these factors or elements were argued by both sides.
Just 1 second, I'll post that.
Whether the denial of the continuance creates an injustice for the movement, whether the cause for the request was unforeseeable,
there's a link for Canada,
whether the cause for the request was dilatory practices, and whether the opposing party would suffer any prejudice, injustice, or convenience. Looking at the Fleming factors, I don't need to make a great deal of factual findings. The main thrust, as I'm understanding it, from the motion and the argument today is the issue of Mr. O'Keefe sitting at counsel table. I think I've made sufficient allowances for him to be near and present, but not at counsel table. I don't find that there's an injustice. Unforeseeable or unforeseeability. Certainly, I don't think this is an unforeseeable ruling based upon the scant case law that's available and the fact it's a matter of discretion for the trial court. I think certainly both sides have noticed and can expect as experienced attorneys that sometimes the courts rule favorably to you and sometimes they rule against your position. And if there's issues that need to be brought up before the court and well in advance of trial, they should be. But when issues are brought before me by motion, I rule on them, and I have not been dilatory in my rulings.
Dilatory. Love his legal vernacular.
And as opposed to the other side, certainly this case has been pending since around September of 2020. It's now July of 2024. I think the state has every right to and is ready to go to trial. I think both sides are and should be ready at this point.
Dilatory, is that the opposite of diligent?
There's been more than sufficient time for preparation. Again, the incident complained of and the information happened in September of 2020. I don't find that there's any prejudice from the rulings that I've made regarding Mr. O'Keefe and where he's sitting. So in addressing the Fleming factors and the McKay factors based on the obtained factors, I will deny the motion to continue.
Give me just 1 second. I'll get you a link too.
All right. Is that all of your motions, or is there?
I have two left, Your Honor. The first one is pretty small and simple. I wonder if the court would have any objection if we bring in this with the mechanics of this trial, a very small portable table, so that Mr. O'Keefe can have something to put his laptop on. We can put it back there.
How big of a table?
Like a little tray table.
Like a dinner table or a TV tray?
The equivalent of like a TV.
If it's the size of a TV tray, I think that'll be fine because it'll just sit right in front of him and that shouldn't block ingress or egress from that side.
Very good. Thank you, Judge. My last motion, if I may.
Yes.
Your Honor, this is a motion for the court to voluntarily disqualify itself. And if the court would be kind enough to allow me to make my record, I'd appreciate it.
And we want you off the bench,
This is an
Judge.
appeal to the court's sense of honor, integrity, and to the oath that the court took when sworn into the office that it now holds to support and defend the Constitution of the United States, specifically the Sixth Amendment right to a fair trial, and the Florida Constitution's Due Process Clause in Article 1, Section 9 of the Florida Constitution. The court's order of September 18, 2023, denying Ms. Benefield's request for judicial immunity, on page 26 in the third paragraph, Your Honor, reads as follows. Considering the totality of the competent and substantial evidence admitted during the stand your ground hearing, the state has proven by clear and convincing evidence that the victim's homicide was not a singular act of necessary self-defense, but was instead the culmination of a lengthy, concerted effort by the defendant to eliminate the victim from her life and the life of their child. When the defendant's efforts to enlist the assistance of law enforcement, child protective services, and the judicial system failed, she took matters into her own hands, as she told Dr. Broder she would. Now, had the court issued a neutral order that would have or should have read that the state has met its burden by clear and convincing evidence for purposes of the request for judicial immunity and the defendant's motion is denied, it would have gone on and said whether the shooting was justified is a question of fact to be properly submitted to a jury at the trial of this matter. How can Ms. Benefield possibly receive a fair trial with the conclusion that the court reached in that order? Make no mistake, that order says Ms. Benefield is guilty of the crime with which she is charged. Ironically, we're here this morning to select jurors, and the court is going to instruct them that they are to presume Ms. Benefield innocent of the charges against her. How in the world can we expect that of the jury when the court cannot extend that presumption and honor it based upon what the court's words, not ours, what the court wrote in its order? That conclusion specifically, Judge White, help explain why at this stage the court has, among other things, quashed defense witness subpoenas and told the defense they can prove it some other way, when it's our case and our right to a fair trial, and we decide the best manner in which to present our case within the rules of evidence and criminal procedure, why Your Honor has denied Jack O'Keefe from assisting me in the trial of this case, and why the court at the last hearing that we had on its own suggested to the court that perhaps the right action on behalf of the court would be to file, on behalf of the state, would be to file a Daubert challenge. The record of that hearing will specifically note that the defense requested a Daubert challenge in response to the state's motion. The state never did. The court suggested that to the state at that hearing, and lo and behold, the very next day, the state filed a motion requesting a Daubert challenge. As the court knows, according to Florida Statute 3810,
I can't find my referral link anywhere.
You can move to recuse the court based upon demonstrated bias or prejudice. Rule 2.330 of the Florida Rules of General Practice in Judicial Administration likewise provides for the disqualification of the trial judge. Now, here's the problem. There's a time limitation. It's imposed in the Rules of Judicial Administration and the case law. And frankly, I missed it. And I missed it because at the time the court entered its order on September 18th, 2023, it was quite some time following the Stand Your Ground hearing, and we were not only focused on filing the appeal, but by the time the appellate court acted and the second DCA denied our motion, I had just missed it. And I take responsibility for that. That, therefore, is why I asked the court, based on its order, to voluntarily take the high road and step aside voluntarily.
Take the high road.
And give, in doing so, objective recognition to the oath Your Honor took to support and defend our constitutions, which includes, as the court knows, an opportunity for a fair trial by an accused, by an impartial jurist. So I asked the court to do the right thing.
So we are watching a pre-trial motion.
There's no getting around
pre-jury selection
in that order.
Would you like to be heard?
The judge is flabbergasted.
Judge, I would just like to say that in a stand your ground hearing, the court is the trier of fact, and the court does need to make factual findings. And the fact that that is being held against the court, I think, is quite unfair. The court is not the trier of fact in a jury trial. The jury is. There has been nothing in the court's rulings to show any animus towards this defendant. I quite frankly think this is the defendant's MO. This is what she does. When someone doesn't agree with her or a judge does not agree with her, she does a motion to recuse. I feel like this should have been done a year ago if it was going to be done. It was only done at this late time because of the court's rulings did not go in the defense's favor, and this is their last-ditch effort. The state would also say, if the court was inclined to grant this, that we just flip-flop judges right now and start this trial this morning. Thank you.
All right, thank you.
We just flip-flop judges and start the trial anyway.
Sorry, Your Honor. Any final thoughts on your motion?
No, sir.
All right. Good. Thank you very much.
I'm not going to give it any more either.
All right, so the jury questionnaires, we don't have them yet?
Like 10 minutes and we'll be
70 jurors. Okay, so we're going to be sending up the questionnaires. We're going to get them about 10, 15 minutes, I would think, according to the clerk. And we are going to have the panel of 70. So for those of you who are here in the courtroom, the veneer panel that we're going to bring up is going to take both sides of the courtroom.
Which means you have to leave.
So what I've done is I've asked court administration to open up another courtroom that will have audio or video so you can listen in and it will be made available. And that's courtroom 5A. 5A. So 5th floor, courtroom A. In fact, it's basically just right down below where we are right now. And that'll be open for the jury selection.
So I'm going to explain
process.
what just happened in just 1 second here.
So at this point, I guess we'll take a break, and there's not much to talk about until we get the questionnaires. Remember, I'm going to make the initial statements to the jurors, welcoming them, giving them some background information. We're going to get through the charges, the parties. Oh, the witness lists. If you haven't done it already, I need the witness lists of witnesses you expect to call. So I'm introducing everybody, the parties, the folks in the courtroom, so the jurors, potential jurors, have an understanding. I need your witness list so we'll then cover the substantive portions of what I'm going to cover for the jury selection are really just going to be hardships and knowledge about the case. And for those folks who don't express any pre-existing knowledge about the case or the facts, I'm going to then let them go to lunch, be an early lunch, ask them to be back downstairs probably around 1:15. This is the plan. We know about the best laid plans. The hardships, then we'll keep here to talk as a group about their hardships and what they have and the issues they have. The other jurors that express pre-existing knowledge or think they might have knowledge are going to be taken down to courtroom 6E down the hallway, and we'll bring them back individually and take care of them one-on-one so as to not taint. I know we talked about this, but I considered groups of 5, groups of 3, but I ultimately set it on individual.
I'm going to tell you why I don't think he does in just a minute.
Right. So like I said, they're going to bring the jury questionnaires. So the attorneys and parties don't go anywhere, because as soon as the questionnaires come, I start looking through them. All right. I'm going to guess I'll probably come back down around 9:20 and just kind of see how things are going. Or are you going to be here? I may just reach out to the clerk and just see when the questionnaires got here and come back down after I've given you a few minutes to go over them. All right, we'll be in recess until then.
Judge.
Okay, so they go into recess here. We're a few minutes behind. Obviously, this was this morning. The judge did not respond. He gave him the cold shoulder. Now, to his credit, he gave them an HDMI cable and a TV tray. Okay, so they got those two in, and then he had the audacity, after getting the HDMI cable and the TV tray for his assistant, to say, "Now, Judge, we want you off the case." And the judge just stared at him through all of it. It's just like, really? But if you listen to the argument by the defense attorney, and basically this is all just another. Getting the judge kicked off the case is basically a continuance, because there's not another judge who's sitting out there who has nothing on his docket that could just step in today with jury selection and continue. It would be giving them an extension. It's one more way to ask for it. It's a last ditch effort, and it sure doesn't make any friends on the bench between the defense and the judge. But they did it. He made the motion. He got it on the record. But in his motion himself, he says, "I realize I missed the deadline." He missed the deadline to recuse the judge based on things. And because of that, he missed the deadline, the judge does not have to respond. This is not a timely motion. Is my understanding. I don't think that anything that's happened, and that's why the judge said they make, sometimes they rule in favor and sometimes not. This is court. This is normal. That was his response. That was his response to this. So he's just gives him the cold shoulder and did not even the pleasure of getting a no out of you. So I don't know if they're going to show jury selection. They possibly will. Usually they don't show the jury members, which makes it really, and they're not mic'd. So, and this, if we've noticed one thing about this court, it's that the mic situation is terrible. I've boosted this by about 37 decibels to get what we have there, and trying to trim off the noise and stuff. I'm doing the best I can on this, but the mic situation is really awful. So we'll keep an eye out and see if jury selection is covered. If it's not, what we have on the schedule today, this is exciting. This afternoon at 2:00, we have the Karen Reed trial hearing, where the prosecution for the Commonwealth has to decide if they want to press charges or retry the case. So that's going to be a little spicy, I think. I think that'll be interesting because we're going to have a lot of talk about jurors and a lot of talk about things that the defense thinks the judge should do right now about dismissing charges and all that. But anyway, we'll get there. So we've got some court hopping. We'll be watching for more happening from down there in the Benefield case in Manatee County. That's in Florida, by the way. So we'll be doing both. If you're a little bit late, what case came in late? This is the ballerina trial, or the Ashley Benefield trial. Just background on this: Ashley Benefield met her husband, or the victim in this case, at a political function, right? So they at least they had one thing in common. They texted each other for about 2 weeks, 13 days to be exact, a little under 2 weeks, and then got married there on day 13. So courtship was a bit of a whirlwind, you might say, and then straight into marriage. She got pregnant. He actually reversed a vasectomy so that she could get pregnant. She got pregnant, and then they separated. There was a custody dispute over the child, and this is, over time. I think the child is now 5. I think now. I don't know. And basically, right before that custody dispute was going to be settled, she was moving some things out of the house. He was helping her, and she claims that he hit her with a box or something, and she shot and killed him. Yeah, well, it went down like that. So it's an interesting case, definitely interesting. She's not your typical, the image you might have in your head for somebody who's going down for a second-degree murder in trial. But that's her. That's where we are. We're not behind. They're currently in break. Their jury selection is just starting this morning. It may take a day. It may take 2 days. However long it takes, we're going to pick up the case when it comes back. If they show jury selection, we'll try to bring that to you as well. But if they do that, we will also break from showing that to bring live the Karen Reed hearing this afternoon. So now we get to do a little bit of court hopping. Yay! Who's here for some court hopping? And I'll keep an eye out for court whenever something happens there out of Manatee County, to bring that to you as well. Crazy Cat Queen says, I got engaged after 4 days to my current hubby. There you go. For some people, you just know, right? You just know. I know that Mrs. R.A. and I had a fairly short courtship as well, but it was measured in months, not in days. But let's see, it was definitely less than a year for sure. Samantha Terry, thank you very much. Says, congratulations, 59,000. I hit 59,000 subscribers yesterday morning. I was actually sitting next to Mrs. R.A. I pulled my phone out and looked at it. I said, hey, watch this. And I dragged down and refreshed on the screen, and it went over 59,000. And she's like, wow, that was cool. So it was awesome to be sitting with my wife and see that number roll over. Thank you to all those new people who have joined us. We think you're going to love it here. This is what I like to think is the best place to watch true crime on the internet. And it's because of the amazing community we have here. We all love the same thing. We love watching these court cases. We like learning. We like talking about it. We like discussing things in a friendly way. And basically, at the end of the day, even if we don't agree, we like being friends afterwards. And that's, I think, what sets us apart from a lot of the other things that are out there. So thank you. Please join us. Please join us. Bring your polite questions, and bring your different viewpoints as well. Let's just remember to be respectful at all times to each other, as well as to the people who are in court, and that will be great. Samantha, thank you for your huge super chat. Appreciate that. All right, let's see. Cheryl B, thanks for the kind words. Let me see if I can get you court. I think we had Judge Simpson. Oh, Thal's coming in. Hang on 1 second.
Call from
Thal.
Good morning, Thal. How are you doing this morning?
Good morning. Excuse me, but you were introducing me correctly, as if reminded by the waifu in chat. I'm Paul, the husband of Tisha S. Okay, that's
right. Have you made it official, or the future husband?
Oh, no. I'm the current husband, the current online husband. Oh. So there you go.
I guess that's all it takes to make it official nowadays is just say I do on chat. And you're good to go.
Listen. She makes the rules. I just apply them. Okay, I'm not trying to fight the power that is. Okay,
you've learned the proper. All right? You've learned the proper role of things.
I have a daughter and a granddaughter. I have a daughter and a granddaughter. So no, I don't fight the power that is. I just kind of nod and go, sure.
Tisha says my current ex-husband.
There you go.
Oh, man.
The ladies make the rules. I just nod my head and go, yes, dear, that makes total sense. Whether I get it or not, it's one of those things. You don't have to get it, Scott. You have to get it. Yeah. You see what I'm saying? You just,
get with it. That's what you need to do. How was your weekend, Thal? Any?
It's going pretty good.
Since there wasn't anything political that happened that's worth talking about, what did you do? Pickles, not politics, right?
Oh, wow. I thought I told a law person.
Yeah. Well, that's for another channel. I'm sure there's a channel out there that has a lot of content today. It's just not ours.
Oh, yeah, no,
that's
they
where we go.
They do. They can discuss it. We don't care about that stuff.
Yeah. We care, but we don't talk about it here.
That's all right.
What are you looking forward to this week as far as trials go? I know the Karen Reed trial. I think a lot of people are watching for that today because, at this point, anything could happen. We could have the judge dismiss charges 1 and 3. We could have the judge order a jury hearing, a post-verdict jury interview or something. We could have the state drop the charges altogether, or it's lots of different outcomes.
Well, here's the three things on those three subjects. The proper thing to do at this point by the state, so not the thing I want, not the thing, that my heart tells me, no, I don't care about that. The thing that they should do, the prosecution should do, is drop the case. Morally, they should drop it.
Drop the whole thing, or just charges 1 and 3?
No, they should drop the whole thing. It's such a mess. It's so convoluted. It's such in the weeds at this point, thanks to the investigators, that as a prosecution, I don't know how you can look in the mirror and morally justify saying I'm carrying out justice, because you're not. And you're not. You're just not. They bungled it. It's not your fault. It's one of those things that if you're going to convict somebody, I fully believe in the prosecution system that if they look at it and say to themselves, for me, it's a step of integrity on their part. You know what I mean?
Yeah.
Because integrity-wise demands that you drop it, because you don't know, and it's not going to be able to be proven because the investigators bungled it so hard. You know what I mean? The thing about getting the jury in, I doubt that's going to work, because courts don't like to do that. That's a big red herring.
It's rare.
Well, it's not. It's red. Yeah, it's not rare. It's impossible. You just don't do it. The goings on, and the difference for people to understand is that the conversations that happen inside deliberations is sacrosanct.
Yeah.
The court has never messed with that, and we're talking like ever in our history. They don't mess with it. Period.
Yeah, but the court does,
outside of that are different.
The court does have the ability to go and ask them and say, where did you disagree, or where did you find agreement? We saw that in the cold case trial. Was that in Tennessee? I think that's what the defense obviously feels should have been done. In hindsight, looking back, they say this should have been done. They didn't say anything at the time, but that level of questioning, I think, is appropriate.
Right. Well, there's ways that they could do that, Scott, but it's going to be really, they're going to have to cut some fine friggin' lines if they even attempt it. I think more than likely what we're going to see is that they throw out 1 and 3. The judge agrees, you know what I mean? Or, like I said before, the more convoluted way to do it is for the judge to say, no, I'm not going to grant that, but tell the defense, you should appeal this, or something to that effect. And then for them to have an emergency hearing with an appellate court saying, we need to throw these out. The judge pretty much, you know what I mean? They kick the ball to you guys. You know what I mean? That way she's not trying to set precedent. She's not messing with it and doesn't go on her record.
Yeah.
Because the judge would probably much rather have a hot potato shoved to another court, a higher court, than have egg on her face for getting it wrong. And it be appealed later, because that would be even worse. You know what I mean?
Yeah.
So I think that's where that's headed. But yeah, this defense, if I'm not wrong, and tell me if I'm wrong, this defense seems to be playing games all day, which I really don't think is a good idea.
He's an old school lawyer. Okay? He's like 74 years old, and does things differently. Like, he's not up to the times on law. I don't know when the last case he tried was. It's strange. I don't know why Ashley hired him, because she did. I believe this is a hired attorney, right? This isn't a. I just don't know. I've got some questions. He seems to be not up with how things work in court. The fact that he missed a deadline, that's a huge red flag. Okay, you don't miss deadlines unless you're Sarah Boon. That's her deadlines today. She's going to miss all those. She's not going to file any motions. But
well, I mean, it could be two things with this that I think that might be going on with her lawyer, because it strikes me as such. One is that he's pro bono, so he's doing it for free, so that's why she took him.
Is he?
Or he might be a friend of the family, so he came out of retirement to do this, and she's being pushed in that direction by a loved one. That could be it. Or he's just super, super cheap, and that's why she went this direction.
Yeah.
Because you're right. Because everything he's doing right now screams at me that he's not. At some point, he was competent. I don't know about anymore.
I think he was comfortable taking the case with his sidekick at his side, which once he didn't get Mr. O'Keefe sitting there at the table right there next to him to really help with some of the heavy lifting. That's why they filed the motion. I mean, that's the main item in their motion is we need a continuance because you wouldn't allow the guy who's doing most of the heavy lifting at the table. Well, that guy is not a lawyer. The judge said, I'm only allowing lawyers at the lawyer table. And lawyers and defendants, that's it. So anyway,
well, and that could be it too.
He's not recusing himself. Everything was in that motion was pretty much denied, except for the HDMI cable and the TV tray, which were sort of verbal motions. But Greeners gifted 5 memberships this morning. Thank you very much. Debbie Faison Cook also gifted a membership. Thank you. Way to welcome the new people into chat. Fall. It's going to be going to be a good day today. I can feel it.
Yeah, it's going to be a great day.
I think it's going to be a great.
I got tackle hooks from the wifey, so right there.
I got to let you go now. That's as far as.
All right, buddy.
See you, man. All right, bye. Okay, Chris Wallace gifted a membership as well. Thank you very much for your generosity, welcoming new people here. Jennifer, good to be here. Good to have you back. Great. Well, we'll get you in green here in no time. Make sure your gift setting is turned on. The court will rule on the motion. He's taken it under advisement, but he's made it clear he's going forward. That's the funny part. So he will rule on it. He'll find the right words for it, I'm sure, but it might be down the road. I don't think he has to do it right now. Nanny upgraded membership to jury. Nanny wanted one of those soft, cushy chairs that jury gets. Congratulations, Nanny. We'll go ahead and move you right over to that new soft virtual chair. Cachette comes into the super chat saying, congrats on 59,000 subs. The 60K community post, confetti cannon, pyrotechnics, dancers, elephants, and cake are prepped and ready. Let's get there. It's gonna be awesome. It's gonna be wonderful. Thank you for that. I appreciate that. Let's see. Andrew C. Says, good morning. 15 months, Andrew. Good morning to you. Welcome. Thanks for your support. And Frosty Jen gifted a membership this morning as well. That one went to Valhalla Awaits. Congratulations, Valhalla. Let's see. We need to take our emotions from trials and actual evidence. Yeah. What time is the Karen Reed hearing? Not till this afternoon. It's about 2 o'clock Eastern time, Morgan. So we have some time. If they're not going to show jury selection out of the Ashley Benefield case, which I don't think they're going to do, honestly, then we'll do some court hopping until then. But either way, we're going to have some fun here. Let's see. We were a little bit early. Let's see what courts are in session today. Let me do a quick scan. Ooh, just got a business text. Somebody needs my town got a grant, and they want to buy a camera that can do some live streaming. So they want my advice on what to buy. All right, so let's see. We got maybe Judge Bryant. We haven't been with Judge Bryant in a long time. Let's see what she's up to.
You too, Judge.
Thank you. That looked like Miss Carla Marable in there talking to my prosecutor. Good morning, Miss Marable.
Good morning, Your Honor.
How are you? I'm doing great. I am. Were you in Dallas? Were you in Dallas?
And I looked for you. And I couldn't find.
I don't understand why you couldn't find me. It was only 20,000 people there. I was there, but I got sick afterwards.
Okay. Mr. Sack had trouble getting on Zoom, so I decided if the client is here.
Okay, is he there yet, or are you saying we waiting on him?
He's outside.
Okay, that's a super noisy court, and I just can't handle the noise. The Zoom talking over each other. Laura 77, 60,000 soon already. Thank you, Laura, for 17 months of support. Or 16 months, 17 soon. Sid says, starting a new job today. Congratulations, Sid. Good luck as well. Sad I won't be able to watch all day like I have for the past 8 months. Congratulations. What's the new job? It sounds like an awesome, exciting opportunity. 8 months on a roll, says Gigi. Good morning. All right. Good morning. Good morning to you, Gigi. Appreciate that. Welcome. Let's see. Judge Bryant is a little bit much for my ears this morning. I slept beautifully last night, by the way. Probably too much. Let's see if we can go here. I haven't been here, I think, ever.
Please wait.
You have a guy wearing a hat in court.
Esperamos por el interpreter ahora.
We waiting the traductor.
Yes, sí. Hold, please.
Okay, it's good. My English is a little.
Thank you.
They're gonna wait.
Español, it's muy poco.
Okay, they're waiting for an interpreter here. We'll see what happens.
Good pronunciation.
Good conversation. JBL, where have the 15 months gone? Always lurking. Thank you, JBL. That's been a fun 15 months for sure. Sid, I was looking for your comment. What was the new job? If you care to share, you don't have to, but I missed it. I saw this. Thank you. Hopefully it's your dream job, and it's like completely fulfilling and gives you all the opportunity and challenge and growth potential possibilities you hope for. Josh, I got the text. I have not pulled it up yet. I haven't looked at that one. Let's see, Carolyn, I normally don't do House Oversight Committee stuff because it tends to run political. I know there's a lot of stuff going on over there, a lot to watch. Why is that judge never in the courtroom on her bench? By the way, I love her necklace. Bryant, I don't know. She always works from home. And they've got like all the dividers and everything still up. Like there's like fiberglass or plexiglass.
Good morning, Mr. Cruz.
Good morning, Your Honor. How are you?
Interpreter's here.
I'm well, sir. Thank you for your assistance this morning. Mr. Maria Hara is here. Mr. Cruz, may I swear you in, please?
Yes, ma'am.
Do you swear that you will interpret in the case before the court this morning to the best of your ability?
I do, Your Honor.
Thank you. Good morning once again, Mr. Correa Parra.
Buenos días, una vez más, el señor Correa Parra. ¿Es correcto?
Sí, señor. Buenos días.
Yes. Thank you. Good morning.
First of all, sir, would you please kindly remove your hat? You're making a court appearance, and I would ask that you remove your cap.
Translate that cough.
La jueza le está pidiendo que se remueva la gorra por el protocolo de la corte, señor. Ok, gracias.
Bueno, con gusto.
Thank you.
It's a pleasure, Your Honor.
Thank you. We're on the record in case number 24-2375ST. Mr. Parra, you are appearing for arraignment purposes this morning. Ms. Misdely is the defense attorney who will be assisting you in the arraignment this morning.
Estamos presentes en el caso 24-2375 ST. Señor Parra, presente está la licenciada Misdely, que es la abogada que le presta a la corte temporalmente para que usted tome la mejor decisión posible en su caso. Y hoy solamente es la lectura de los cargos, ¿entiende?
Sí, señor.
Yes, ma'am.
Those are some good trials.
I'm going to ask to place you, Ms. Misdely and Mr. Cruz, in a breakout room, a place where you can have a private conversation so Ms. Misdely can go over all of the issues regarding the arraignment before we get started on the record.
Para protegerlo usted, la jueza nos va a poner en una habitación electrónica en privado para que usted pueda hablar con la licenciada y también utilizar mis servicios de intérprete en su caso, ¿entiende?
Sí, señor. Gracias.
Yes, I understand. Thank you.
Your screen will ask you to join that breakout room, and when you're done, please return to this meeting.
Ahí en su pantalla va a aparecer una invitación para entrar a otra habitación. Por favor, acéptela.
Ya.
Okay.
All right. So they're off in their own little meeting. Jackie, those are some fun trials. Those are good ones. Let's see. Road trip with Sleepy Baby and RA. Can't complain. Jalen, I'm getting excited. We're going to be leaving on a road trip here in less than 2 weeks, and I'm taking y'all with me. So it's going to be a lot of fun. Let's see. I call the window seat. I call the driver's seat. I'd like to drive for as much as possible. I actually love driving. So with a good navigational aid, I think I can do most of the trip myself. We can't skip this part where this is live, but we'll see if we've got some other courts to jump to. Let's see who is. See if Judge Oakley is up and about yet this morning, shall we? Judge Oakley's desk is live this morning. We could watch his desk, see if something exciting happens. I don't think it will. But Selena Carr just gifted 5 memberships. Congratulations to the awesome people who received them. Elizabeth, Tracy, Princess Lukey, Sunshine, and Bo Pete. I'm a retired Canva project manager. How do you call the seat next to the driver? You call it mother-in-law seat? The seat next to the driver? Here we call it shotgun. And you call it by saying shotgun. I suppose Mrs. Araya already called shotgun. Yes. We're going to cover Sarah Boon? Yes, we are. Absolutely. We've covered every single one of her letters thus far, and a lot of some of the filings in her court case. So, especially when attorneys are asking to be released. No more of those, though. Couldn't drive because he used the wrong side of the road. We use the right side of the road. Literally. We say co-pilot. It's better than the backseat drivers. I can do it with a co-pilot, but backseat driving is not my thing. Is RA hiring a bus for us to use on tour with him? So I call dibs on the back row of the bus. No bus. I will take you along by. I haven't decided if we're going to live stream the trip itself, like the drive across the country. because here's what I know I cannot do. I cannot have a screen in the car with me watching chat. Like, I cannot be watching chat. And I'm pretty sure that with that much driving, anyone else that I assign to watch chat and read me quotes or chats, they're going to get car sick. So I'm not sure how to do it, but we might stop along the way and show you where we're at and things like that. But we could live stream the whole thing and just have it be just a drive video. I mean, just wind noise. I don't know what we'd give you, because you don't want the kids. Are we there yet? Are we there yet? Are we there yet? Are we going to go to Sarah Boon at all? Possibly. That I have not decided on that one yet, if we're going to be there in person. Okay, this judge is doing nothing. Let's jump back to 2.
Would you please pronounce your last name for me?
Costres.
Thank you, Mr. Costres. You're appearing for arraignment purposes this morning. Ms. Misdely, the defense attorney available through the Indigent Defense Counsel, who will be here to assist you in the arraignment, is currently with another client. I wanted to let you know that I saw you were in the waiting room. I'm going to ask to put you back in the waiting room if you don't mind. Thank you. And if you'll just have a little bit of patience, it shouldn't take too long.
All right. Thank you.
You're welcome.
Living ghost. If you get caught with a screen in your car while driving, we'd be able to watch your trial. We are going to play road trip bingo, at least the family is. We've made a bunch of bingo cards for that. Crusoe, what do you mean by we do the Sarah Boon trial? Do we watch it or find a lawyer for her? You know, Crusoe, I think I did as much I could do to find a lawyer for her as I could by broadcasting her advertisement. I think that got much more potential views from potential lawyers who might be able to assist her than even posting it in the judge's break room, which is what she wanted. Sarah Boon's going to be a media circus. It's going to be crazy, but Sarah Boon is in Florida. She's in Orange County, Florida. Where's Orange County? Is that down south or up north? I don't know my counties well, someone can tell me faster than I can Google, I think, because you guys are quick. Well, we got a hump day yell from outside during a fire alarm. Hopefully no fire alarms at the hotel on the trip. And I don't think I'm traveling on a Wednesday, so probably not on 2 counts. Karen Reed hearing is today, Donna. You are not wrong. It's 2 o'clock this afternoon. We're going to do a little court hopping. So far, we have nothing by way of video from the Ashley Benefield actual jury selection. If that is made available to us, we'll bring that to you. So we're going to do some court hopping until that happens. We anticipate that the jury is going to be able to be picked today. That's my gut feel. Hello, Brandy. Hello, Brandy. Welcome. Good to have you here. Brandy is absolutely amazing creator. For those that don't know, you should know Brandy. Brandy has done a podcast on the Karen Reed trial, an in-depth podcast that is, I think it's like in the top. It ranks in the top in all podcasts in true crime. Just amazing job. You've got to watch that. Her coverage is fantastic. She also has a very cute little dog that lives a better life than most of us. They're on the beach. So yes, make sure you give her a follow. She's a great friend of the channel as well. And she has very similar, it's Lucy. Lucy Cam is the dog. She has a very similar audience to what you find here. So if you like the group that you find here, the type of communication, it's different, but it's very similar as far as friendliness and just great people. So you can't say enough good things about her, and her channel is exploding.
Thank you and welcome back.
Gracias y bienvenidos de regreso a todos.
We're back on the record in case number 24-2375ST.
Estamos de regreso en el caso 24-2375-ST.
Ms. Misdely, did you have an opportunity to review the allegations on the complaint, nature of the offense, and the possible maximum penalties with Mr. Parra?
Señora Misdely, ¿tuvo usted la oportunidad de conversar con el señor Parra y explicarle la acusación y las opciones bajo la ley que él puede tomar.
I did, and we will waive a formal reading of the misdemeanor complaint.
Oh man, that means we don't
and
get to
our
hear the
plea of
charges.
not guilty. And Mr. Correa Para will be retaining counsel.
We're going to jump to Judge
Sí,
Boyd.
conversé con el señor y él se va a declarar no culpable hoy. Él va a retener su propio abogado y va a representarse con ese abogado y estará listo para la próxima fecha con el fiscal.
All right, we're going to jump to Judge Boyd because we're not going to hear the charges in this one.
Herbert Morales.
She's calling roll.
Michael Rodriguez, Marvin Ortiz, Johnny Munoz, Abel Favala, custody, David Mendoza.
Late.
Mario Resendez, custody, Lindsay Hernandez, Michael Hernandez, custody, Kashana Hullaby.
There she is.
Jasmine Gallegos, custody.
It's denied. The continuance was denied this morning.
Rubencheck, custody.
For the motion we watched.
Roberto Mendoza Perez.
Let me mute her roll call for a minute. The motion we watched for the continuance of the trial in the Ashley Benefield trial this morning, that arguing, the discussion, the judge has denied that. We're moving forward with everything. If he had granted it, it would have stopped immediately. But where he said, bring us the paperwork, we want the jury questionnaires, they're going forward. So it's been denied. There will be no continuance. We'll be going to court. Okay, let's finish roll call here.
Everyone, please confirm.
Please confer. Talk amongst yourselves. Donna Adelson hearing today too. It's a busy week. It would be awesome if I could get there at the same time as Peter Tragos and Brandy Churchwell. It would be awesome to meet both of them at Sarah Boon. That would be incredible. Judge has pretty flowers today. She has a ton of flowers. She's got the whole store there. A pink bouquet of roses. A mixed. I'm not sure what the white and are those are carnations in the back. The white and the pink. And then looks like yellow roses as well. And something, wow, lots of flowers. They did get the cable this morning. The judge did allow the defense to get a cable to Mr. O'Keefe.
For the people ran up in the car, they got it back. I don't have any footage here. They got the lot. This is such a work. We've done it. And I want to see the
Everyone's just getting up to speed in the judge's court. Just a moment here, we'll begin. Let's see if anybody else is live yet.
I'm sure you could. Judge, what's your rule on that? If I did the underlying plea, can I be on the MDR too? I think I can.
Oh, it depends on if they put somebody on it already.
Yeah. We actually need to file some machines on it.
No Judge Cedric yet this morning. He might have the day off.
I know right now.
Let's jump to Kansas briefly, shall we? Here we go. Big jump. We'll be back with Judge Boyd in just a minute. See what's up, what's happening in Kansas. I think this is the misdemeanor docket. Well, showing their bling. Everybody's quiet. Read that the jail in Bexar County is one of the worst in Texas, and that's saying something. Well, that's where she says that they saw cockroaches fighting, right? Looks like we've got some activity here in court, but just waiting for people to unmute. Look at the guy who's... What's that behind him? Is that like a wine rack behind him? Oh, he was lean. Oh, that's his ceiling. I thought that was a... It's like an open ceiling. Mr. What's his name here behind me? Preston's phone. That ceiling completely threw me off. I'm like, how is he standing at that angle? And Butler County Detention Facility, looks like their bookshelf is at capacity. Does it look like it's sagging? Like the bookshelf is sagging behind it?
Savannah, can you place Devin and me in a breakout room?
Yep.
Thank you.
You're welcome.
Haley Steffen is making the minimal appearance, as is the only fan in her room, just above me. Just her hair is there, and the tip of the fan. Tommy Roderick looks like he's at work. Lots going on here. Greeners says 10 membership gifts if the bookshelf caves. Oh, man. It's close. It's close. You can see it starting to sag a little bit. Ryan Goering, there in the bottom right-hand corner. Backlight not doing him any favors, but does have a nice fish mount there on the wall. Looks like a trout. The tail looks more like a trout than a bass. I guess they heard us and they got rid of the only fan. Who's behind me? I will disappear for a minute. Nobody. Oh, they've moved. Preston's iPhone. I think Preston's iPhone is nearly flat on the table, and he's leaning over it. That's why we're seeing a, looks like a drop ceiling that's either being, looks like it's been torn down. Because I've done that. I've torn down a drop ceiling that has those furring strips. And you can see the pieces where the ceiling tiles were pulled off of that, and there's still little corners that are stapled on that. It's a lot of work pulling a drop ceiling down, because everything just falls on your head. I have a bookshelf that sags like that, says Debbie. I do as well. I've got it right next to me. It's Mrs. R.A.'s, but honestly, I think it has more sag in it than the one that the Butler County has. Tommy's just hanging out. Oh, we've got the forklift operator doing the thing. He's like, well, while I wait, I might as well help load these boxes of evidence onto the forklift. Guess he's got the volume turned up. You know, ain't nobody got time to stand around and wait for court. You know, there's forklifts to load. Preston might be on a job site as well, doing a remodel or something. Gage has nothing else to do, sitting there wearing his Under Armour shirt, which is a nice one, I might add. Love those Under Armour shirts. For a second, I thought that Mundot Aiken was on an airplane, but then when I blew it off my screen, I realized it was just ceiling tile I was looking at. I want to see how high they stack this pallet. Wonder what it is. What's in the boxes? Preston looks tired. Preston looks like he works hard. That is hard work. In construction, especially pretty much anywhere in the country right now, working construction is a tough job. It's just so hot. Usually when you're doing construction, you don't have the benefit of having functional air conditioning because either the walls are gone, or the AC has not been put in yet. Mike W says, "Oh, Preston looks tired." There was another one that said, "Who's this?" Oh, Greeners. Tommy's in the Dunder Mifflin warehouse. They're shipping out paper, boxes and boxes of paper, copy paper. He's made himself a seat out of product. Also, now the backlight not helping him at all. Quick, a pro tip, light in front of you is going to make you look a little bit better on Zoom than light behind you. AI analysis of what we're doing so far that says, now viewers are discussing the judge's flower collection and Preston's eccentric basement. Chase, welcome. Wow, Chase. Making an appearance.
Let's go on the record.
There's Judge Webster.
The person at the jail, have you talked to your attorney yet this morning?
Yes, ma'am.
Is Mr. Patterson available?
I'm going to go in the top.
Is your attorney Mr. Patterson, or is it Mr. Andrews or someone else?
Mr. Patterson.
All right. Is he available?
I do believe he was talking to the DA.
All right. Well, there's Mr. Regier. Is he talking to you, Mr. Regier, or to the other one?
Your Honor, my understanding is Mr. Patterson is present in a breakout room with my colleague, Mr. Canfield.
All right.
Mr.
Andrews, shall we take up some of your cases then?
Mr. Regier is the person they created the character Data from on Star Trek. He is
Mr. Durat is here. Preston's iPhone is what it says on the screen.
Very well, Mr. Durat, please start your audio, your video and your audio. Will be on the record in 2024 TR 801, State of Kansas versus Preston Blake Durat. Please announce appearances.
Jared Regier on behalf of the state.
Joshua Andrews on behalf of Mr. Durat, who is also present.
And how do you wish to proceed, Mr. Andrews?
Your Honor, I have received the discovery but yet reviewed it. I also have a telephone conference scheduled with my client to discuss the case with him for later this week. So I would request a brief continuance.
Very well. Any objection, Mr. Regier?
If the court is continuing the bond in this matter, Your Honor, the state does not have any objection to a continuance at this time.
Mr. Durat, your bond is continued. That's the $500 cash bond you posted back in December with all existing conditions and the added condition that we give you to reappear, and Missy's going to give that, or the clerk's going to give that to us right away. Savannah?
We can put this on September 9th, Your Honor.
Thank you.
Mr. Regier.
September 9th at 9 a.m. All parties need to be back here by Zoom. September 9th at 9 a.m. Defendant again continued on bond with that added condition.
Mr. Regier looks like Data from Star
Nothing
Trek.
further. We'll be in recess on Durat.
Mannerisms.
Mr. Patterson, the person you have in the county jail, please.
Your Honor, that is Amber Severs with an S, and we are ready to proceed.
Zoom's going nuts. So many people on it.
We are on the record in 2023 CR 350, State of Kansas versus Amber Marie Sievers. Please announce appearances.
Good morning, and may it please the court. State appears by Devin Canfield.
Your Honor, Darren Patterson appear on behalf of Amber Sievers. Ms. Sievers does appear from the Butler County Jail. Your Honor, this is a case where after talking with Ms. Sievers, she is prepared to enter a plea of no contest and resolve the case. In discussing that with Mr. Canfield, though, they are needing to reach out to the victim and talk to the victim before they're prepared to proceed with the plea to get it over with. Your Honor, because of that, we do have an agreement for a bond, an OR bond to present to the court. I would tell that, Your Honor, that she does have one failure to appear in January. But in looking at Casper and talking with her, she was in prison, and that's the reason for the failure to appear. She's now in our Butler County Jail because she did finish that sentence. She has been released to Butler County on this hold, but that is the reason she had that failure to appear. Rather than hold her until the next date in order to get a plea done, Your Honor, there's an agreement for an OR bond. We'd ask the court to accept that and adopt the same. Thank you.
Thank you. Counsel, did your office not send notice to the alleged victim that this hearing would take place today and that plea and sentencing could occur?
We did, Your Honor. Actually, what happened is we have been in contact with the victim in this case. The victim, last we heard, intended to send us some updated documents, but the documents they attached were the same that they had previously sent. This was not my case. Today was the first time I'm seeing it. And upon seeing that, I do think it's worth following up with the victim. I do agree with Mr. Patterson that the only failure to appear is when the defendant was in custody on a different case. So I would also recommend the OR bond.
It always seems to me that if the victims get notification of these hearings and choose not to come, that even though they know we could have a plea and sentencing, that should be considered. Nevertheless, I will go ahead and grant you this one continuance for this reason. And what amount of OR do you recommend, counsel?
Your Honor, the bond is currently set at $6,000 cash surety. Before that, it was a $3,000 cash surety. I think a $6,000 OR would be appropriate.
So you're recommending we go from a $3,000 surety to a $6,000 OR?
It is currently a $6,000 surety, Your Honor.
Well, rather than go to an OR, can we just reinstate the $3,000? You know if the bondsman would do that?
I don't have that information, Judge, for the court today to feel comfortable enough to have my client, say we can agree to that. I just don't know.
All right. I'll go with the $6,000 OR, but where are you going to live, Miss Sievers, between now and the next court date?
I will be at my parents' house in Greensburg.
And will you be on any kind of parole or
Yes, ma'am.
supervised release?
Yes, ma'am.
You have an officer to report to in your other case?
I do.
All right. 6,000 OR. And what court date do you want her to come back, Savannah? That's September 9th?
September 9th works.
September 9th at 8 a.m. Be back here by Zoom. Miss Sieverts is a part of that bond.
Okay, thank you, Judge.
Any comments?
Judge, the only thing I would have is that Ms. Sievers, when you do get released, make sure you contact our office to give us all your contact information.
Okay.
Thank you.
Thank you.
Right. We'll be in recess at this time. Anyone else at the jail?
I believe that's it, Your Honor.
All right, thank you.
Judge, if I could have a breakout room with Mr. Canfield, we're going to finish talking about some cases.
That'd be fine.
Thank you.
She's got a busy morning lined
Ryan
up here.
Gearing here and Ian Loser.
Oh my goodness, what an unfortunate
Or
name.
Loser.
Yeah, I think that was a mispronunciation.
Yes, Your Honor.
And where's your client?
I don't have that on my docket, Your Honor. I'm not sure why.
You don't have the case on your docket?
Uh-uh. Give me just a second, please.
It's set for motion of some sort. Let's look at that. On the record in BU 2022 TR 2063, State of Kansas versus Ian Michael Lazur. Please announce appearances.
Jared Regier on behalf of the state.
Could you tell me why this is on the docket? What is it set for, Your Honor?
Okay, Mr. Ryan Gearing, counsel of record, I believe, for the defendant. I show that on May 20th, 2024, the state appeared by Jared Regier. The defendant failed to appear. Mr. Gearing did not appear. So we set this over to today for a motion to revoke diversion. It looks like.
Okay. Okay, I got you. Okay, we don't represent Mr. Luzier on a motion to revoke diversion.
All right. I don't know if you filed a motion to take yourself off the case or not, but if you haven't, you probably should, as you know. Okay, so did we get notice to the defendant, Mr. Regier, notice of the diversion revocation?
One moment, Your Honor.
So that's our current count. You guys are asking exactly where we are on the subscribers. 59,079. We just hit 59,000 yesterday morning, which is just awesome. So we've got
Your Honor, the state's understanding is that a motion to revoke diversion was filed with the court on March 18th of this year. It does appear to include a notice of hearing for an earlier hearing date back on May 20th. Listing both the defendant and retained counsel Ryan Gearing with a certificate of service attached. I am showing a return in my file, which would appear to indicate, quote, return to sender, unclaimed, unable to forward. More recently, it would appear a notice of hearing was filed with the court on June 14th. It appears to indicate, quote, on March 18, 2024, a motion to revoke diversion was filed in this court, a copy of which is attached. A hearing on the motion is scheduled before this court for the 22nd day of July, 2024 at 9 a.m. And I do appear to have a return in my file, which indicates, quote, your item was delivered to an individual at the address at 3:34 p.m. on June 17, 2024.
All right, I find that notice was given and the defendant fails to appear. Motion granted by default, and we'll need to set a trial on stipulated facts. Can we do that on the 9th?
That one's full now. We'll move to September 16th, please.
All right, September 16th, 9 a.m. will be the trial on stipulated facts. If there's nothing further, we'll be in recess on that case. We'll now take up Brian Nicholson's case of Sharif Abdul Mitchell. Are they here?
I do have one more, Your Honor, whenever you have time this morning.
Let's take that up. I'll go ahead and take that up. I can find it. What's the name of your defendant?
McCutcheon, Your Honor. It's 24 TR 1613.
Are you showing that on the docket today, Savannah? McCutcheon, you said?
Yes, Your Honor. It was added kind of last minute, so if you printed your docket sheet early, it probably won't be on there.
Okay.
Florida would post it online, Lenova, for sure. That's what they do.
There he is. We're on the record in 2024 TR 1613, State of Kansas versus Gage Alexander Lee McCutcheon. Please announce appearances.
Jared Regier on behalf of the state.
May it please the court, Ryan Gearing for Mr. McCutcheon, who also appears via the Zoom application.
All right, Mr. McCutcheon, can you hear us?
Yes, Your Honor.
Thank you. We're here on one count of reckless driving. I understand we're set for plea and sentencing. Is that correct, counsel?
Yes, Your Honor. He would like to enter a plea of guilty to that charge, please. And the state's going to be recommending a $400 fine and court costs and to close the case at that point.
That's your agreement, Mr. Regier?
Your Honor, pursuant to plea negotiations in this matter, that is the state's understanding.
No controlling term, right?
Correct.
Your Honor, while the
hold on.
Well,
Hello? 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 Can you hear me now? Never mind. We tried. Let's see. Where are we going? 2? Yeah, 2.
No, Your Honor.
And you understand with the guilty plea, you are admitting the charge. Is that what you want to do?
Yes, Your Honor.
Do you also understand that you'll most likely be found guilty and will have given up your right to trial and your right to appeal any conviction?
Yes, Your Honor.
All right. Tell me in your own words what happened with you and your automobile in Butler County, Kansas on May 3rd of 2024 that would constitute reckless driving.
If it's helpful for the court, Your Honor, we'll stipulate that there's a factual basis, given that this is a misdemeanor.
Okay.
I still want to hear him say what he did.
I do see a citation and notice to appear were filed alleging that on May 3rd, 2024, 2019 hours, the defendant with a Texas plate was on the 2000 block of West Central in El Dorado, Butler County, driving a 23, looks like Kia Ninja, so he was on a motorcycle.
Ooh. It's not Kia, it's a Kawasaki.
It just says reckless driving. You're stipulating that it was reckless. Mr. McGeer, have you anything further?
Your Honor, for the court's edification, to supplement, if the court is finding that a guilty plea is being entered in this matter, the officer's notes for testifying in court attached to the ticket appear to indicate, quote, high speeds weaving around traffic all over the roads.
All right. And in the 400 block of a very busy area, so I will accept the defendant's plea as freely and knowingly and voluntarily given with a factual basis to support it. For sentence, I will order a $400 fine and 108 court costs for a total of $508. Mr. McCutcheon, are you able to pay that today?
Yes, Your Honor.
And can you pay that at the courthouse there in person?
He cannot, Your Honor. He lives in Texas.
All right.
Will the journal entry be done if he gets to call up and try to pay it today? Will they know?
It wouldn't. That's why I asked if he would pay in person. If you can't pay in person, give us a few days to get the journal entry filed, and then you can pay online at paykscourts, COURTS.com. And be sure and have your full case number, including those zeros.
Understood, Your Honor.
30 days to pay. And if you don't, your license will be suspended. You'll probably have a private collection agent after you and your attorney, all that stuff he's told you. So if there's nothing further.
Your Honor.
Yes, Mr. Regier.
2 final matters. Is the court finding that a guilty plea has been successfully entered for purposes of the journal entry?
Yes, Mr. Regier, I do so find.
Thank you, Your Honor. And secondly, pursuant to the summons that was filed with the court in June of 2024, that appears to include a hearing date of September 4th, 2024. Does the court find that that hearing date is still necessary in light of the goings on in today's hearing?
The court finds that that hearing should be removed from the docket. No, it is not necessary, Mr. Regier.
Thank you, Your Honor.
You're welcome.
Thank you, Data.
If there's nothing further, we're in recess. Mr. McCutcheon is excused. Mr. Gearing, as I understand that was your last hearing, you're excused.
Heather, we followed the motion this morning. They're in jury selection right now.
We'll take up Philip Weiser's case with John Warren. Is John Warren here?
Your Honor, no. Mr. Warren is not available this morning.
All right, let's go on the record then. We're on the record in 2022 TR 3627, State of Kansas versus John Tracy Warren. Please announce appearances.
Mr. Warren's not available for court.
State.
Philip Weiser appears on behalf of John Warren.
And you were starting to say there was a reason why your client's not here, sir?
Yes, Your Honor. He is out in the field in, I believe, somewhere around Great Bend, and he doesn't have cell service. This morning, I've tried to contact him and have been unable to. He told me when I last spoke with him on Friday that that most likely would be the case. He's fully advised of the issues in the hearing today, but he's unable to make a Zoom call to call in.
I don't know. You got to make court.
When you say he is out in the field, I tend to think of a farmer, but maybe an oil field, some other field.
He is a construction worker, Your Honor. I'm not sure exactly what his duties are, but he's away from local contacts and cell service, and he has great difficulty in making phone calls and receiving emails or texts, quite frankly.
Mr. Regier, the state's response to what I understand is a request for continuance.
One moment, Your Honor.
And I might add that the defendant failed to appear for first appearance, but that I think there was some confusion because the counsel for the defendant had filed a motion in order to continue the case.
Scott Smith is chugging that water.
May 17th, defendant said defendant was present when we set today's date with counsel, and he said he was going to apply for diversion. Did he ever apply for diversion?
Your Honor, this is a case where it would appear a diversion agreement was filed with the court back in August of 2023. Subsequently, it would appear that a motion to revoke diversion was filed with the court, alleging certain outstanding terms and conditions of the diversion agreement. However, some new information has been brought to my attention insofar as the motion to revoke diversion is concerned. The state would move to withdraw the same.
Well, there you go. Motion is withdrawn.
Whoa.
I think that resolved the issue for now, at least, Mr. Weiser.
Yes, it did. Thank you, Your Honor. Thank you, Mr. Regier.
All right, we'll be in recess. Mr. Weiser, if you have no one else on the docket, you are excused.
Thank you.
Make some room for a few more people here on the Zoom.
Are Mr. Hamey and Mr. Voshell on here? Attorney Hamey and Defendant Voshell, are either of you on here?
Put out warrants for the both of
We
them,
are
Judge.
on the record in 2022 TR 2608, State of Kansas versus Mark Voshell. Jared Regier appearing for the state. I'm showing Jess Hamey, attorney of record. This is on for hearing on motion to revoke diversion. I don't know if this is one of those cases like we had earlier today with Ryan Gearing where he thought they were off the case for the purpose of this hearing, although I think they're still attorney of record, having not filed a journal entry allowing to withdraw. So, Mr. Regier, the state's position today on this motion to revoke diversion.
One moment, Your Honor.
Well,
computing response. Please wait. I love Mr. Regier. This guy is entirely professional.
Your Honor, this is a case where I am showing an appearance bond in the file. It appears to be an OR bond in the amount of $1,000 and includes today's date and time, July 22nd, 2024 at 9 a.m. The state's understanding based off of my notes is that this matter was previously before the court on a motion to revoke diversion on July 8th of 2024, at which time the defendant appeared by Zoom with counsel, and the matter was set over to today's date and time. I am not showing any orders in the file insofar as withdrawing the motion to revoke diversion that have been filed with the court in this matter, so the state would move that the same be granted.
motion for default judgment granted. And trial on stipulated facts will be what, 9/16 at 9, Savannah?
That works, Your Honor.
All right, 9/16 at 9, trial on stipulated facts.
We do have Judge Boyd going on as well. I'm watching her courtroom
Oh, is James Patrick Squire here, Mr. Andrews?
Your Honor, I was going to make inquiry because I did not see his name on any of the screens. If is Mr. Squire present?
We moved a bunch of his hearings. Didn't we move them to today, or did we move this one to another day, Savannah? I thought we had a couple that we put on the same day. The traffic and
You want to hear Judge Boyd?
On the 17th.
She's not talking right now.
Or I spoke with him on the 17th, where indicating that I believe it was last Monday that he had a new hearing and that I was going to be appointed on it. I was thinking that, and it's always possible I misunderstood him. I was thinking that the new hearing was set for today's date.
You're right.
We'll switch to Judge Boyd as soon as she starts talking.
But if that's not accurate, that may explain why he's not here. But if that is accurate, I would ask if I could have him call him, because when I spoke with him last week, we had talked about that. He had said he was going to be present for the next Zoom hearing, which again in my mind was today, and I thought that was also what he was referencing.
Your understanding was right. I do see we have both cases on for today. We have 23 CR 434 and we have 2023 TR 363. We did just see him in the last week or so and tell him to be here. And I did order him to contact you and tell him that I am appointing you. If you haven't received both appointments, I'd ask that Savannah check on that for us to make sure you get them both. But you want me to recall it a little bit?
Yeah, if I could try calling him, because he's always kept in good contact with me, and he did call me right after the hearing like you had directed him to. So if I could try calling him, I could see if I could figure out why he's not here.
That would be fine. How about Preston Patterson and Chris Pate? Are you both here? Attorney Pate, are you here?
Richard,
Mr. Paul.
Richard Paul on behalf of Mr. Pate.
All right, we're on the record. 2023 CR 300047, State of Kansas versus Preston S. Patent. Please announce appearances.
Jared Regier on behalf of the state.
Richard Paul on behalf of Chris Pate on behalf of Preston Patterson. Would the court please inquire if Mr. Patterson is here?
Yes. Preston Patterson, are you here? Not seeing him. He's not in custody. He's not at court security, is he?
He is not.
Bench warrant.
All right. Recommendations. Well, first of all, Mr. Paul, you have any requests?
Why is everyone just skipping out on the judge?
I believe Mr. Patterson was eligible for diversion. I don't know if he has sent that in or not. I'm appearing on behalf of Mr. Pate, and I would just ask for a continuance.
Well, I do show on May 20th when the defendant was present by Zoom.
I thought I remember seeing his name.
He did say he was going to apply for diversion. That Savannah, could you look at that note? I think that note is confused. I think that was the defendant was Patterson, not Attorney Patterson. I think Paul, do you have your notes, or Mr. Regier, the one to show who the attorney was? Was that Mr. Pate with him May 20th?
Right, we're going to jump to Judge Boyd.
Your Honor, on May 20th, my notes would appear to indicate that the defendant appeared by Zoom with Mr. Pate as counsel.
Yeah, that's what my record shows as well.
All right, here we are.
Oh my gosh. See, the problem is, I always say whenever you're doing sort of a road trip,
that's good advice.
You can't say, oh, we're going to drive 9 hours or we're going to drive 8 hours. You just
That's what
go with the flow. But it's hard to do that. So
we booked out the 9 hours.
Sometimes you just want to stop in certain areas to see what they have first.
Okay.
I think everyone's probably about done conferring. They're ready to kick off business here with Judge Boyd.
And how was the weather? Well, when we say nice, what is it? 70 degrees with a nice breeze? Oh, well, that's good. It was hot and humid here. Well, we got Actually, last night when I was sleeping, all of a sudden I hear this noise and it was rain. I was shocked. Mhm. And I don't know what was happening, but they were having some sort of festival or something was going on downtown.
There you go. Something was happening. So right now, the Ashley Benefield trial, they're doing jury selection. That is not being televised. We watched the motion almost live this morning. The motion for continuance that the defense asked for, that was denied. The motion for the judge to recuse himself was ignored. And so the motion, let's see, they motioned for an extension HDMI cable, which they received. They motioned for a little card table for his paralegal to have in front of him so he doesn't just have the laptop on his lap. And that was approved as well.
Sheriffs, you guys are having a July fair, career fair.
I guess they're hiring. Bexar County Sheriff's Office. If you're post-certified, you might want to run down and check that out. Maybe they'll actually pay for your certification as well. Need to stop and see the world's largest onion. We're going to see the world's largest pitchfork, the world's largest rocking chair, I think. There's a couple of world's largest we're going to stop and see. Anyway, later today we are going to be taking live the Karen Reed hearing, where the prosecution is going to determine if they're going to proceed again and how. The judge will help them with that.
Oh, that's right.
I don't know where it is. I just know that it's on the route, and we'll be stopping there. Lots happening today, obviously. We're Pickles, not politics here, but the world of politics is moving and is shaking today as well. So if that is something that you're interested in, there could be breaking news in the form of resignations from high political offices today. They have like 15 large items. Largest mailbox, we're seeing that one. You can send a letter in it. If you stop by my house, you can see the world's largest buffoon. What we're talking about, I'm taking a road trip. I'll be gone for about a month and a half, but I'll be working almost every single day of that. So for you guys, it won't be very different other than that I won't be here in my courtroom, which I have here. I'm going to be in an Airbnb out west, either in Utah and Idaho. We're staying in those two locations. So what happened in the Benefield trial? Nothing other than some motions this morning. We read the motion together. It was about a 7-page motion, and then we watched the response and the argument in front of the judge. It was denied for the most part, so the continuance was denied. Everything's going forward. They're just in jury selection, which is happening off camera. They've got batches of 70 jurors lined up. They'll go through the first 70, and if that doesn't work, they'll go through the next 70. Today's probably going to be entirely jury selection. I do think they could probably get a jury in one day in this case, but we're probably not going to see anything from the court until after the jury's seated. So we're going to do some court hopping after we watched that motion. If you want to rewind, you can see that this morning. Ms. Benefield was in court and everything. It looked great. Sounds not the best. I'm working on that as much as I can to get it good for you. So now we're court hopping. Right now we're in Bexar County, which is San Antonio, Texas. Judge Stephanie Boyd, excuse me, it was one of our favorites. Honestly, we've sent her flowers ourselves and watched them delivered live on her stream. She's a great judge. She's got a huge heart and she doesn't put up with any BS. So watching those two things come together are awesome. Let's see. Judge Webster seems to be everyone's skipping out on her court. We can jump back there for a minute, see what's up
with
there.
a law enforcement officer by falsely reporting information intending to obstruct. And I understand, where is Mr. Ayden?
Oh, you're on. He's here. He's in my office.
Oh, he's in the office? Okay, there he is. All right. And how long a continuance are you asking for?
Well, Judge, if ideally, if we could maybe go out 6 weeks
6
on
weeks.
this.
Well, we were here May 28th and the defendant was granted a continuance, I think. Let me double check. Okay, May 20th, 2024. Let's go back a little more. He's asked for additional time since December 19th of 2022.
You know, he just started a new job, and he's confident that we could get this done next time.
Mr. Regier, what's your response?
Well, Your Honor, the state's understanding is that this is a case with some quite significant age. The case number appears to be 22 CR 042. This would also appear to be the second hearing on the motion to revoke diversion. And it looks like the agreement for pretrial diversion was filed with the court back in over a year ago in April of 2023, as well as under the waiver of rights, I believe, section, I believe that covers it does appear to include certain provisions concerning a motion to revoke diversion. So the state is prepared to proceed at this point.
The court is going to deny a request for continuance. The diversion agreement was filed April 13th of 2023. The defendant has had consequently a year to comply with any and all conditions.
Well, Your Honor, I would, if I may, please, my client couldn't decide whether or not he wanted to hire a different counsel, whether he wanted to retain me, and you know, he just finally decided that he would like to retain me, but he hasn't really finalized that. We haven't really finalized that. I would like some time to prepare. Can we have maybe a short continuance, maybe not 6 weeks, but however short the court wishes to make it. I do not want to not do a good job for my clients on this, and can we please give me time to prepare? It really is my request more than his.
Taking a hit, stepping in front of the bus for the client.
Let me see what the allegations are. It's alleged that he violated the diversion by failing to pay the court costs in full, still having a balance of $258. That was on March 18th of 24. He had that balance. 2, he failed to successfully complete the assigned online education course. And 3, he failed to complete a written letter of apology and submit it to the diversion coordinator for distribution. So
that's 3 strikes.
Those are the allegations. It's not just a matter of coming up with the money to pay the case off. And even if he does, you'll want to check with the prosecutor. I don't know if the prosecutors want to give him more time on their contract since it's taken so long.
Well,
Mr. Regier, what was your response again?
Your Honor, at this point, the state is prepared to proceed on the motion to revoke diversion. Again, this is a 2022 case, and the state is eager to reach a final disposition in this matter.
Well, the court is too, but I understand the dilemma that the defendant has put counsel in. Not that counsel had to take the case under these circumstances, but he has, and I understand him wanting to do a good job. Is there any way we could squeeze this in 2 weeks, Savannah?
Tinsel and TP, welcome.
Or even put it, let's see.
Got some great friends in Australia.
Maybe counsel could do it at a Wednesday 1:30 docket even in the next couple of weeks. What's your Wednesday afternoons usually look like, Mr. Kinder? Particularly around 1:30-ish?
On what day, Your Honor? Or
let me see what the clerk has available our first Wednesday.
Your Honor, we can do in 2 weeks on August 5th at 9 a.m. Wednesdays at 1:30 are looking a little tighter.
All right. How about 2 weeks, August 5th at 9 o'clock, Mr. Kinder?
Yes, that should be fine, Your Honor. That should be fine.
But I don't want to go any more than that because this defendant has had an unusually large amount of time to work on this. All right, Mr. Ayden, can you hear me?
Yes. Yes.
I don't know why this case is taking so long to get back to me for resolution, but you are going to be continued on bond with all existing conditions and the added condition that you be back here with your attorney, and it can be by Zoom again, August 5th at 9 a.m. Don't be absent.
All right.
All right, if there's nothing further, we're in recess at this time.
Your Honor, two points.
Moment, counsel, Mr. Regier.
Your Honor, this is a case where the only appearance bond I'm showing in my file is for 2500 OR for a hearing date back in July of 2022. This is a case where it would appear that a diversion agreement was filed with the court. Subsequently, in April of 2023, the state would be requesting clarification as to whether the court considers that bond the controlling bond under these circumstances.
That bond was satisfied when the defendant took diversion. I'm going to issue a new bond. I will set it at, I'm going to make it 300 OR. But Mr. Ayden has to go into Sallyport 2 right now in a breakout room and set up a time to sign that new bond and be processed on this revocation. So Sallyport 2, can you handle that? I don't mean Sallyport 2, I mean court security 2.
Yes.
All right, so Mr. Kinder, if you want to join them, you can. Well, you're going to have to because your client's with you. So just take the invitation to the breakout room and you'll set up a time with the officers when he needs to get those picture prints and new bonds taken.
And Your Honor, if it is the court's order that this matter be continued, does the court consider the motion to revoke diversion outstanding at this time?
Yes.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
You're welcome. David Becker, are you
Thank you,
here?
Amber.
Attorney Becker with Mohammed Ahmed.
David Beckham? Oh, Becker.
On the record in 2023 CR 488, State of Kansas versus Mohammed Ahmed. Jared Regier for the state. Attorney David Becker, are you here for the defendant?
Why does she have so many no-shows?
Attorney of record David Becker and defendant Mohammed Ahmed seem to fail to appear. At the hearing on May 20th, 24, the defendant failed to appear and the attorney failed to appear. And apparently, as some type of professional courtesy, we continued it to today.
And they failed to appear.
I don't know if notice went to the defendant and counsel that we continued it. But on March 27th, at first appearance before Judge Ricky, bond was set at $2,400 cash or surety, and defendant had retained counsel.
I wonder if
On
their court
December
system
18th to 23, there was some
has a flaw
confusion
in the
about
notifications.
when the defendant thought the hearing was, and the bench warrant bond forfeiture issued with the no bond hold. And I'm going backwards, October 10th to 23. Defendant said then he was going to retain counsel and bond was set at $1,000. So, Mr. Regier, recommendations.
Well, Your Honor, under these circumstances, the state would respectfully defer to the court as to how it wishes to proceed. In my notes from the previous hearing on May 20th, it would appear that neither the defendant nor counsel for the defense appeared, and then the matter was continued over today's date and time, July 22nd, 2024 at 9 a.m. I am showing an entry of appearance with respect to attorney David Becker. It looks like that was filed shortly preceding that hearing on May 17th, 2024. And along with what appears to be a quote motion to continue to June 7, 2024 at 9:30 a.m. But my notes would appear to suggest that the court did not take up this matter on that date and time indicated on the motion.
That was a motion for judgment.
Your Honor, it appears to be without, again, as I do not represent the defendant in this matter in my role as prosecutor, I cannot speak to the motion itself,
welcome.
but it does appear to be entitled
Good to have
Motion to Continue to June 7, 2024 at 9:30 a.m. For the court's edification, I would also note that there does appear to be an appearance bond in the file for $2,500 professional surety for an appearance date on May 20th, 2024 at 9 a.m.
So we have actually continued the motion for judgment on bond to today that was filed March 5th. Are you agreeing with that?
Your Honor, it would appear so based off of my notes.
Your Honor.
I'm sorry, Savannah, did you start to say something?
I show that the motion for judgment on bond was withdrawn because the defendant was picked up on the warrant. And then just also for the record, there is another motion to continue that was filed on July 18th to continue this court date.
Well, I didn't see that in the file. Let me see. Okay, July 18th. Motion because of unavailability of counsel. Again, one of those where they think they filed the motion and that's it. They don't have to come to court without even asking the judge to grant the continuance. I don't know if they served you with a copy of that, but it was just recently filed. Hearing date scheduled for 9 a.m. July 22nd. Attorney Becker away on a long planned family vacation, July 19th through 29th. Unavailable to appear for court on July 22nd. Attorney did not request the July 22nd date. Attorney Becker recently mailed a payment to receive discovery records. Defense and his attorney reside in Kansas City, Missouri. Well, I have several problems with that motion. Why would an attorney take a case, rhetorical question, why would an attorney take a case for a day that he knew he was not available? But then he says he didn't ask for the 22nd. Of course he didn't, because his client wouldn't ask for a revocation. And he never stuck around to get I don't know how they do things in Kansas City, Missouri, but apparently the attorneys can just file a motion and the judges will later endorse it and say, okay. But here, I'm used to the attorneys asking and getting an answer before they just do what they want to do. I am inclined. Are you asking that the motion be granted, Mr. Regier?
One moment, Your Honor. Your Honor, in accordance with my duty as an officer of the court, I am not showing any motions to continue in my file besides the one that was filed with the court on May 17th, 2024. As I do not represent the defendant in these proceedings again in my role as prosecutor, and as I am not aware of any such motions being filed by my office, I hardly think I am in a position to request that a motion filed by the defense to be granted when it is not my office's motion in the first place.
Looks like he filed the motion July, let me double check. Looks like he filed that July 18th, 7:58 a.m. And I would not have been in the office the 18th or the 19th, but typically when that happens, they are directed to the duty officer for the week to address that. Let me check my email. But again, I did not grant the continuance, even. And he didn't even serve you a copy of it, apparently, Mr. Regier.
Your Honor, in response to that particular inquiry, this is a case where the information appears to have been colleagued by my colleague. This is information that appears to have been signed by my colleague, Mr. Sweeney. However, I do not appear to have any notes from him in my file in regards to the requested continuance.
Well, I'm bothered by the way this has been done. And not
Unfortunately,
having
our
any
hands are
notes
tied.
that another judge approved it. Or that the county attorney gave an official receipt or response. And that they failed to appear before.
LJ, congratulations on the 2-month membership milestone. Thank you very much for the kind words for those who are gifting.
But since I was
K-Rag,
unavailable for those
thank you.
2 days, I'm going to extend this just a short bit. And I wonder if see, the problem with that is the defendant didn't even come to the last hearing, and he didn't come to this one. So preferably I would issue a warrant, but counsel, he's been paying for counsel to do something for him. All right, what's the next available hearing date you have for motion for judgment on bonds, Savannah?
Your Honor, our next available date is September 16th still. Is it still set for motion for judgment on bond, or was that withdrawn when he was picked up on the warrant? I thought this was just
fine. I didn't see it withdrawn. Did you file a withdrawal of that, Mr. Aguirre? I didn't hear you mention it.
Your Honor, based off my records, I am showing that the motion for judgment on bond was filed in March of 2024. There does appear to be an appearance bond in the file for a subsequent hearing date on May 20th of 2024. However, at this point, I am not showing any orders withdrawing the motion for judgment on bond in my file.
So where are you seeing, Savannah, that it was withdrawn? Is that in the notes, or do you see a document?
I see that the hearing that was set for motion for judgment on bond on April 29th was canceled because the defendant was picked up on the.
We'll be watching the Karen Read Through live this afternoon. We're going to cut to it.
So, but yet we still have the hearing on today's docket.
That's going to be in
Today isn't set
3
for a
hours.
motion for judgment on bond. It's just a control hearing because they posted bond.
Who's the red screen of death?
Oh.
Who's this?
Hey.
Scott Smith just went all red. Maybe he just put his red tape over the camera. I didn't see what happened. Dropped his computer. Broke the camera.
We're all talking about.
Walger, the ballet dancer, that's the Ashley Benefield trial. They're doing jury selection right now.
From Mr. Regier?
They're not showing that, so we're watching
23
other courts
CR
while we
488, last name Ahmed, Your Honor.
Oh, he put his,
So we're
his
still
finger
on the
over the
same
camera.
defendant.
Spilled coffee on the camera. I don't know what he did, but now he's yellow. There we go. We're back. Oh, he's lighting one up. That's why.
Okay, so Savannah, which day on the docket notes are you seeing now?
He's covering his camera while he smokes.
It's just on the hearings, Judge. It just says the hearing for 429 was canceled. Defendant picked up on the warrant. It's not in the notes tab. It's in the hearing tab.
And Your Honor, it would appear that there was previously a hearing on April 29th that was canceled on a motion for judgment on bond. The notes I have from the May 20th hearing would at least refer to the motion for judgment on bond, at least in passing. However, both today's hearing and the previous hearing does appear to be for control purposes, as best as I can tell.
Judge Webster, this is taking long enough.
I'm going to continue this to September 16th at 9 a.m.
James and Tommy have been waiting patiently, and they're here, Judge.
For control, and if the state needs to file a motion to set aside or an order to set aside their motion for judgment, please do so.
Very good, Your Honor.
And we'll be in recess. We'll now take up, let's see, is John Levitt here for Chase Hall? On the record in 2024 CR 127.
This is bizarre.
State of Kansas versus Chase Christian Hall.
At this point, you've got to think maybe something's wrong with our system.
Jared Regier for the state. Is Chase Hall here? Yeah, it looks like maybe he's been removed from the docket, Savannah.
I'm going to go back and watch the rewind.
I have him on my.
What Scott
Yeah,
Smith
it looks like it was continued to 9/23/24. So do you have him left on your docket, Mr. Regier, or do you show him continued to that date?
One moment, Your Honor.
23.
Your Honor, the notes that I have in the file would appear to indicate at least a prospective motion seeking continuance by the defense. However, I do not appear to have any such motions in my file.
There is a motion filed and also an order for continuance signed by you, Judge.
Yes, I do see that. Let's see if anyone from the office signed that. Devin Canfield signed for the state, Mr. Regier, on that order to continue. And that was filed July 17th. How about Brian Nicholson and his client, Sharif Mitchell?
And forgive me, Your Honor, before the court proceeds with the next matter, what was that date on 24 CR 127 for the next hearing?
Chase Hall.
Yes, Your Honor.
Continued to September 23rd.
Thank you, Your Honor.
You're welcome.
And Your Honor, just to let you know, Mr. Squire is now present. So whenever the court's ready.
We can get him real quickly. But while I'm at it, though, what happened to Sharif Mitchell and his counsel? Did they get? I don't see where they continued it. I'll just take that up real quickly, and then I'll
keep her audio going.
Your cases, Mr.
But I'm going to show you the video from him lighting
Andrews. Okay, on the record in 2022, TR 3345, State of Kansas versus Sharif Abdul Mitchell. Jared Regier for the state.
Back up a little bit.
Is Brian Nicholson or the defendant Sharif Mitchell present one last time? Apparently, they both failed to appear.
Cigarette? What's the call, chat? Is he smoking a cigarette, or is this?
This is a motion to revoke diversion.
Something home rolled. Sparky, sparky, sparky. Puff, puff. Oops, cover the camera. Boom. Yeah. So your call on that one.
Filed June 17th or June 7th of 2024. I show that July 5th there was a pending collections review. Then July 8th, the return of service of affidavit for service of motion to revoke. Samantha Steuben alleging that notice was sent by certified mail to the defendant on a street in Wichita.
On the street in Wichita, or on
And that
a
is
street.
what the diversion agreement requires, is it not, counsel?
All right, nobody showed up again, so we're gonna
the last
portal
known
back
address
over to
given.
Judge Boyd's.
Your Honor, under the waiver of rights section of the diversion agreement in this matter, item 9 would appear to indicate, quote, I understand if a motion to revoke diversion is sent to my address, which would then referring to a Wichita address. And that same item does appear to
Odyssey is
be
taking its time.
We're going to go back over to Judge Boyd.
I just appreciate your consideration in this.
Oh, no problem.
You know, I've been putting it off because I always have something, you know, and I just got to go do it. It's like,
Oh, yeah. Okay.
but I can come Wednesday. I can come any day this week.
No,
Just-
and so here's the thing. I'm trying to see, because I have notes that your client was declared incompetent.
Yeah, he was. That's
So-
why I was kind of wondering why it was on the docket.
I don't know why different dates are being put in the system other than the date that I am giving.
Oh, Judge, it's the new system. I'm here on more PF cases and
Looks like San Antonio, Texas, Bexar County's having problems with their court dates as well.
Let me see, I'm trying to get the details up.
Attorney, what is your name?
Oh, we just missed our favorite Burnett Circuit Court judge. Let me see what she had going on. It was just brief. Let's see if she's doing drug court or whatever. Just 1 second.
It's slowly getting me to where I need to be on this thing.
I understand you're brave to navigate it.
This is just a couple minutes ago. We're going to jump to.
And then I got a paper that I've been on a wait list for Appleton housing where my son lives.
I think this is drug court.
So I'm up for that. So I spoke too early telling my boss this, and she couldn't justify continued training me on the front desk, so she had to let me go. So today, my caseworker here that helps with my housing program is going to call down to Appleton and see if I can move in there August 1st and start school and work.
This judge is amazing.
Start school and work? What are you looking at doing for schooling?
I've always wanted to do RN. I don't know if I'm able to because of my felonies, but
She wants to be an RN. She's got some felonies that might be a problem.
So now you're here, you're asking for what? To pay, how have you been paying? What's your payment schedule?
when I've been working, I call and I set up as high as I can go just to get it knocked down. It's been so long.
You still owe over $3,000, and yes, it's been super long. Yes.
But when we had spoke last, you had said if I could pay it, if I would have gotten the Social Security, that you could knock it down to help me with that. Would that still be an option?
Yes, but it doesn't sound like you're still applying for Social Security.
I am. It's in appeal process with Stephanie Crystal, and I guess because the computers are all down on Friday.
I cannot remember this judge's name for the life of me. She's really good with drug court, though. Absolutely amazing. I'll make you cry.
More of that, and then also the workers' comp injury that is going through. So August 19th, when I see my surgeon, he's gonna send me to that doctor that does that disability rating based on surgery.
Okay.
And then I'll have all that taken care of, pay my fines, get my son's fines paid as well, and be able to move forward. I'm so excited. I was so depressed before. I felt hopeless. I didn't know what to do.
So I can't pull up her payment schedule for whatever reason. Her name is not coming up. So is she making any payments? No. No payments, none payments. You need to make payments. And it's been a long time. It's been over a year now.
I haven't been working at all.
And again, that's not the county or the state's fault. The county and the state didn't commit the crimes, you did, and there's fines and fees. I've been very lenient and I've given options of ways that we can work for you and still have the county and state receive some of their fees, but that hasn't been an option yet. Have you looked into borrowing money from somebody or looking and getting to a loan? You need to start making some fees. At minimum, I'm going to say at least $100 a month from now here on out until I get an update on what's going on. I'll give you until probably September to let me know what's happening, what's going on, if you're going to be able to pay this off, where your Social Security appeal is at. But $100 a month, you got to figure it out. If you don't, then a warrant will be issued. You could sit up to 6 months in jail. It's getting ridiculous because this is from 2010.
I understand.
So $100 a month, first payment will be due in August. The second payment will be due in September. I will set another hearing date. If you are in Appleton, you can appear by video, but I'm going to need to know what is going on because we need to get this figured out.
It's a long time to not pay.
If I'm getting this job, which I have an interview for down there, I pay as well. If I could set up bigger payments, could we put on record how much I could deduct off so I could
I'll figure that out once I know your job and then I set a payment plan and schedule. And if you consistently make that payment and show that good faith effort, I'm going to tell you most likely I will be open to cutting some off. But right now it's kind of hard to think about when I haven't gotten a payment in over a year. And again, that these are 14 years old.
It's a long time.
Well, the oldest are 14 years old. So I'm going to set a hearing with you 1 o'clock on October 2nd, 1 o'clock October 2nd. You may appear by video conferencing Zoom if you are in Appleton. If you are still local, then you must appear in person. You're going to give me an update on your job situation, on anything like that. If you do go back to school and you get any type of student loan, if you have the ability to use a bulk amount of that.
Let me jump. I found something we don't normally get to see.
Or most of this.
I'm going to turn this off. She's going to have to pay her fines. I'm going to turn this off. We're going to jump to Wade Mercer, who's doing jury selection and showing the whole thing. So we actually get to see the jury.
Anybody else on the third row? Yes, Ms. Mitchell.
This particular trial, let me see if I can show you what the name is on this trial.
And I think that was one of the things I was going to talk with you about.
Jackson County State versus H.
2005, right? And what was the nature of the offense? I'm sorry? I got you. Okay. Anything about that would affect your ability to be fair and impartial in this case? Okay.
Do love to see a good
now,
jury.
the flip side of that is I just want to know, have you been ever a victim of a crime? I know, Mr. King, you spoke about that, but I want to know kind of the flip side. Have you ever been a victim of a crime? And I'll go row by row, starting with the first row. Anybody been a victim of a crime? No one on the first row, second row? And third row? Okay. Sure. And we've... I'm sorry, Mr. Gilly, you said something?
No good mics on the jury, but.
Okay. Anything about that that's going to be important and affect your ability in this case? Understand. Thank you. All righty. So kind of in closing
This is
here, I just
Florida,
want to
by the
talk
way.
about one more thing. It's called the division of responsibilities. And we kind of touched on this a little bit here, but your job as a juror, right, is to determine the facts, okay? To render a verdict, meaning guilty or not guilty, based on the law and the evidence that you'll hear at trial, okay? It's the judge's job, if the defendant is found guilty, to impose, the punishment or sentence, okay? But your job as a juror does not concern what will happen if the defendant is found guilty. Is there anyone here, though, that says, hey, I would just have to know, in order to find someone guilty, I would just have to know what would happen after that? Can everyone keep those separate? Is anyone here able to keep that division of responsibility separate? That your job as a juror is to determine the facts, right? And based on the law and the evidence, whether the defendant is guilty or not guilty. It's the judge's job to impose a sentence if the defendant is found guilty. Don't have a problem with that or take issue with that. No? Okay. And I just have one last thing is, does anyone disagree with this statement that adults are responsible for their actions and should be held accountable? Does anyone disagree with that? Raise your hand if you would disagree. For the record, I don't see any hands. With that, Judge, I'll tender the panel.
All right. Thank you, Mr. Gill. Ms. Kelly.
Thank you, Your Honor. Good morning, ladies and gentlemen. I'll be a lot quicker than Mr. Gill. She got most of the questions out of the way. So this is kind of an interesting case, especially in the times that we're living in. I've got a coworker who is a Second Amendment absolutist. He is of the opinion that the government shall pass no law to infringe upon one's rights to bear arms. One of the things we talk about is how in Florida you can legally have medical marijuana, but you can't have a concealed weapons permit if you have a medical marijuana card based on the state of federal laws. And he is opposed to that. Is there anyone who is opposed to government passing any laws that infringe on Second Amendment rights? No? Okay.
No hands.
Mr. Gill touched on this earlier. Is there anyone who thinks that if you're convicted of a nonviolent felony, like a business-related felony, a white-collar crime, something like that, that's different than, say, an armed robbery when it comes to whether or not you should be able to maintain your gun rights?
There's one hand.
Okay. All right. So you don't disagree with that if you've got a felony, you've got a felony. So you would have no problem if the charges would say, okay. All right. One of the things that, has been around lately is like President Trump has just been convicted of, I think, 34 felonies or something. And as a Florida resident,
Pickles,
he would not be
politics.
able to own a gun under current Florida law, even though, there's just been a recent assassination attempt against him. Does anybody have a problem with that? Okay. How about restoration of rights? If rights are restored and they don't include gun rights, do you agree that the government should restore all other rights except for gun rights? Okay. All right. I think between what Mr. Gill asked and nobody has opinions on any of that, that's all the questions I have. Thank you.
Thank you, Ms. Kelly. So, ladies and gentlemen, what's going to happen now is Ms. Kelly's going to have a chance to speak with her client. Mr. Gill's going to go over his notes. We're going to meet over here at sidebar, and they'll select the jury. So we'll be out of your hearing for just a few minutes, and then we'll let you know the jury that's been chosen.
See if they keep the stream going for this. Yeah, most courts do not show jury selection, and a lot of you have been posting this. Why are they showing the jury? Most courts don't. Some do. There are some courts where literally you go and you request camera access, and they say, all right, but you're not allowed to do really close-ups of the jury so you can see what they're writing. That's their rule. And we have a tradition where the idea is that jury is secret, but in actuality, it's quite public. The jury sits in public, and anyone can come in and look and see who was on the jury. It's just we've got this tradition where it's secret, and courts sometimes will delay releasing the names, but if you in most trials, if you wanted to go in and see who was on the jury, you could go in and sit down and look at all of them yourself. So interesting here. Let's see. Teresa Super just gifted a membership. Thank you very much. I need to respond to this text, and I can't think and talk at the same time. Just 1 second. Okay, there we go. Spell things correctly. That would be better. Send. All right. Thank you, Teresa. Anyway, this in Florida, there are a couple courtrooms that they do show us the jury all the time. They show us jury selection. We get to hear all the objections, why they don't want to serve, what their prior convictions are, just like as if we were in court in person. This judge seems to hate the defense attorney. Oh, I love it when there's some strong feelings there. By the way, I received a free membership before in a channel of which I wasn't even subscribed. Apparently, YouTube knew you wanted it. You just didn't know yet. Yes, the judge cleared the courtroom of all media. In the Ashley Benefield trial, which is doing the same process we're watching here, but with probably a different set of questions, obviously a different panel. They're choosing a jury, the one that can be impartial and can hear the case and all that, and that's great. It's the same process. It happens pretty much the same way across the country. Because of the number of people that they've brought in for the Ashley Benefield panel for jurors, they kicked everyone else out of the courtroom. They needed all the seats for jurors. The judge made allowances where they said, okay, we've set it up so that you can watch, if you're here in person, you can watch these proceedings from the courtroom just below us, one floor down, so you can see what happens, but there's just no room for you up here. So that's what he's doing. So we just thought that since we can watch this panel being selected, we'd do that instead. This is a much smaller panel. They probably only need, let's see, how many do they have? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Looks like they have one no-show, or one who's been excused already. 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. Okay, 16. I couldn't count right. Which means they're probably only going to sit 6 to 8 jurors, I think. 6 to 8, somewhere in that range, which is common for some court cases. Do you know the county? I do. I can check. Just 1 second. It is... Let's see, 14th Judicial Circuit of Florida. I think that covers a couple counties, actually. Let's see, let's go to 2. Picture's a little brighter on this channel. What the judge is doing right now with the attorneys, and we missed a lot of the questions, is everyone answered questions. The judge asked a few. Both lawyers got a few questions. Some time they could ask questions. And based on the responses they got, they're choosing if they want to strike anyone. First, they're going to talk to the judge. First, you try to get people struck for cause. Like if there's somebody that raised their hand, and this is hypothetical, raised their hand and said, I believe I'm a big supporter of police, and I believe that, that what they do is right and everyone should respect them. And if you were arrested, you're clearly guilty. So you wouldn't be here unless you were guilty. That is an opinion, if you're not able to set that aside, that is not compatible with jury service. Because as you proceed with this case, as you go into a jury trial, if for some reason the judge had to stop the trial right at that moment and turn to the jury and said, I know this is weird, but you need to reach a verdict. You need to come to a verdict right now. We had no evidence whatsoever. We had opening statements, which is not evidence, and then right now you need to vote. The vote should be to acquit. It should be a not guilty, because that's the the shroud of the cloak of innocence that the defendant is wrapped in trial. And so you start from that point. So any idea that would prevent you from being able to start at that point would exclude you from jury service. So they're going to try to strike anyone who has that. They'll also try to excuse any jurors who have some sort of hardship reason, where they're like, hey, I'm a single mom, I've got 75 kids, all of them under the age of 3. They all depend on me. They're at home alone now. The judges can say, you probably need to be there. That's also an extreme case. 75 kids under 3, probably not legal or possible. Can a defendant choose how many jurors to sit? No, I think the law chooses that based on the charge. I believe it's a death penalty. It requires 12. But some states allow 6 on certain charges. Veda Worship, hi from Denver. How's Denver doing? Actually, I don't think we're driving through Denver. We're going to go up north of you a little bit through Wyoming. 75 kids. Yeah, most of you can't relate. I mean, there are times that I feel like I've got 75 kids when they're all running around my house making noise, but Hollywood movies also require 12 jurors. Yes, they do. My stepdad always says the entire process is on trial, not just the defendant. Let's see, is that the argument for jury nullification? Jury nullification of the law, when they say the law itself is bad, so even though the defendant is I guess technically guilty of committing it, we're going to say not guilty because the law is bad? Is that where you're leaning to? Greetings from South Africa. Thank you, Karen. Welcome. We've got a couple of you from South Africa. It's wonderful to get some representation. After the attorneys make those strikes on the jury and get people dismissed for cause or for hardship, then they have they've got some no questions asked, preemptory strikes, where they just can cross somebody off. Judge, we just don't want them. We just don't think they're the person for this trial. And they have a limited number. They probably have 3 each with a panel this size. Well, 2 or 3. Not very many. There's not a lot to choose from. But they'll end up with 6 jurors probably out of this batch because these jurors have not been very talkative. I don't think there's a lot that's going to keep them from serving. I'm of the belief that even one kid can feel like 75 at times. Oh, man. I used to be a scout leader. There's nothing. I was so nervous. I mean, every time we planned a trip, first of all, in the scouting program, they required you to fill out all sorts of tour permits and everything. So I'm doing the paperwork on the back end. And basically the entire burden insurance-wise is put on the scout leader. And it's just like something they just assume. And they're like, well, just carry $1 million policy and, with 0 deductible, and then don't do anything wrong. And that was basically the guidance that I got, is have a huge insurance policy and good luck. And that's just something as a volunteer scout leader that I got to absorb. But we would go camping at the most crazy places, just like, you're driving by and it's like, bear attack last week. Please be alert. I'm like, you didn't get the bear? Nope. So let us know if you see it. And there's a whole bunch of kids who are just pockets stuffed full of candy and good stuff that bears like. And man, just up in the middle of nowhere. And I'm not supposed to carry any sort of personal protection device that would permanently dispatch an attacking animal. Well, I looked at all the rules and I said, that's not a law. The last one's not a law, and that's the one I'm going to break. If I'm going to get in trouble, I'm going to get in trouble doing what I do to protect. Anyway, I'm not sure why I'm talking about that. Let's see. I'll tell you this. There was a time, there were 3 leaders, 3 adults with this group who were hiking up from Utah into Idaho along this ridge line up to a glacier lake, which is just beautiful. I think it's like Bloomfield Lake or something. I can't remember what it's called. Beautiful lake, lots of fish. It was really good, cool. We're hiking up there, and as always, we're all at a starting point, we're like, okay, so we're going over our safety tips. What do you guys do if there's a bear? And we're trying to remind them of what we've trained them about being bear aware and how to hike and make noise and how to alert everybody and not just run as soon as you see one and things like that. And so I'm packing, right? I've got heat. I've got I think at the time I had a 357 with me, which I thought was adequate. It might have been a 44. I don't remember. I had a little bit of a boomstick concealed, and so all the scouts are raising their hands like, oh, do this, back away, don't make eye contact, and going through all these. And the other scout leader's like, no, just tell Scott, he'll shoot it. He's got a gun. I'm like, don't say that. Don't say that. Oh, yeah. Anyway, so he outed me in front of all the scouts. John says, Bloomington Lake is beautiful. If that's the one we're at, yes, that's Bloomington. That's the one. It's got a rope swing. Oh, my goodness. It's got a rope swing where we went one year. We hiked up. It was July. We were camping in I think it was Idaho at Bear Lake, and we drove up to Bloomington Lake, and we're hiking up there, and the last little bit, I mean, it's like hot as blazes, and the last little bit, there's snow on the road. We can't get there, so we have to hike through the snow. We get up there, the lake is frozen over.
Ladies and gentlemen, there was a question that is typically asked that wasn't asked today. I forgot. The attorneys didn't ask it either. And the question is this. This case is set for trial Friday. We anticipate it being a one-day trial. So that those of you chosen for the jury will leave today. You'll be back Friday morning. We anticipate starting the case Friday morning and being done Friday afternoon. That's unless something unusual happens, that's what will happen. Now, if any of you have a doctor's appointment on Friday, you have an issue with Friday, the day, we need to know that now, not later on. So let me ask if any of you have an issue with that schedule being Friday. And Miss Andreessen, you're raising your hand. I don't think you're going to be on the jury anyway, so that's okay. Anyone else?
You're already out.
Since it's rich now proceeding, that's what I do. I'm a vote for private owner. And they typically come in Thursday, Friday, Saturday, Sunday. This will be the last week. I don't know. May not get a call till Thursday.
You don't have anything scheduled right now, but you might have. That's what you're saying, correct?
Private owner and judge, they can call, if they can take a suspicion. I don't know if I would be able to help out.
He's a charter captain.
All right. Thank you for making us aware of that. Anyone else let me back 2 rows, anybody? And then we have Miss Lewis. Yes, ma'am. Let me first answer my question about Friday. Any questions with Friday, or is your question about that? Okay, go ahead.
So that's just my question, is that I missed today, could I be missing Friday as well? I already have some people scheduled. I have to do stuff, but that's an issue.
So it could cause you a work hardship. You just want the attorneys to be aware of your work hardship, correct? Okay, thank you. Anyone else? Mr. Perry?
Work hardship won't get you out.
You have to do what from the captain? Well, I'm sure that being a Federal Bureau of Prisons, that you would think they would understand jury duty. Okay. All right. Thank you.
He works there for corrections. He's like, I'm not sure if my boss is going to let me serve on the jury. Yeah, he is. Anyway, we hike up to Bloomington Lake, right? And we get up there, and there's another group up there, a group of young kids, and the lake is frozen over. Like there's a glacier on one side. It's got a huge, massive peak. It's like hundreds of feet tall on one side of the lake, and then it's a permanent shadow glacier up there. And on the other side, there's an opening that's probably about 30 or 40 feet from shore. There's open water right where the rope swing is. And there's this girl, she's in her swimsuits, bikini, and she goes in the rope swing.
All right, ladies and gentlemen.
She just about died because the cold water just prevents you from breathing.
Let me give the attorneys time to get seated, and Mr. Armstrong.
It was cold water.
All right, ladies and gentlemen, if I call your name, you have been chosen for the jury on this case. So if I call your name, that means you're going to stay here for a few more instructions in just a minute. Ms. Caruso, Mr. Sims, Mr. Hall, Ms. Ernest,
4,
Mr. Sloan,
5,
Ms. Alvarez,
6,
and Ms. Johnson.
7.
You are jurors in this case. Caruso, Sims, Hall, Ernest, Sloan, Alvarez, Johnson. To the rest of you, you've not been chosen as a juror in this case for whatever reason. As I mentioned earlier, we have 3 cases to pick today. So I cannot release you at this point. What I can do is tell you that the next jury will be chosen at 1 o'clock. You very well may not be on that jury, but we won't know until we go through that selection process.
They get 3
I need
strikes.
Sergeant Applewhite to check, make sure the plan hasn't changed. Check with Judge Garcia's office or get somebody to check with Judge Garcia's office and make sure that we still need that 3rd jury so I can tell them what to do. Thank you, Travis.
All right.
So Deputy Pickles are going to check with them. And unless the plan has changed, I need those of you not chosen for the jury to be back at 1 o'clock in this courtroom. At 1 o'clock, we'll go through that jury selection process. We should have between 20 and 30 people here. So we'll take the first X number of people and release everyone else. Then of the ones that go on the panel, as you've just seen, only a certain number of those will go on the jury. So let me speak while we're waiting on that answer. Let me speak to Ms. Caruso, Mr. Sims, Mr. Hall, Ms. Ernest, Mr. Sloan, Ms. Alvarez, and Ms. Johnson. In your case, I need you to be here Friday we're going to try to start at 9. I have first appearances every day. I need you here at 8:45. And if we get through the first appearances early, we're going to start early. The sooner we get started, the sooner we get done. So I'm a big believer in being on time and trying to start on time. Sometimes things come up outside of our control. We can't predict those things. But if at all possible, we're going to start on time, somewhere between 8:45 and 9 o'clock Friday morning. So for Ms. Caruso, Mr. Sims, Mr. Hall, Ms. Ernest, Mr. Sloan, Ms. Johnson, and Ms. Alvarez, 8:45 Friday morning. Now, what we do is we mark off certain parking on the east side of the courthouse. That's between us and the Jackson County Times, between the courthouse and the county commission building. There'll be a couple of bailiffs out there, and there'll be 7 spots with cones are reserved for you to park at. So there's 7 of you. There'll be 7 spots to park. If you get dropped off, that's okay. But if you drive, there'll be a parking spot reserved for you for Friday morning. I'm going to tell you now, I need you to show up Friday morning knowing no more and no less about this case than you do right now. That means you don't talk to friends, don't talk to family, don't read newspapers about the case, don't watch TV. I don't know if it's going to be in the media coverage or not with the internet today. Who knows? But I need you to show up no more and no less. And again, remember, the purpose of that is so that we'll have a jury that will make decisions based upon the evidence and the testimony in the courtroom, not make decisions based upon some other information that may or may not be accurate. Deputy Pickles, 1 o'clock this afternoon for the rest of you. We'll get you in and out of here as quickly as possible. For those 7 need to hang on just a second because we've got to get phone numbers for you. But the other individuals, other than those 7, please feel free to leave, and I'll see you back at 1 o'clock. We'll make it as efficient as we can on that last case. But if you're on the jury, please remain seated because we've got to get your information.
Okay, so those are the ones that stay. 1, 2, 3, 4, 5, 6, 7.
Ladies and gentlemen of the jury,
this is a firearms
sometimes things
possession
come
case.
up. You know, had a hurricane several years ago. There could be all kind of issues that could affect things Friday. So before you leave, we're going to ask that you give the clerk a good contact phone number just in case something comes up. Otherwise, we'll need you here at the time I've already told you. Before we get the phone numbers and release the jury, Mr. Gill, anything else that I've missed?
No, Your Honor.
Ms. Kelly.
No, Your Honor.
All right, so if you'll give your phone numbers to our clerk, Ms. Williams, please, and we'll see you Friday morning at 8:45. Last thing, when you get here Friday, just wait in the hallway. There'll be a bailiff out there, and we'll get you in the courtroom as soon as we get all 7 here.
Let's see. So I'm not sure what extra information needs to give these jurors. Oh, they're just getting their names and information. Okay. We might skip that a little bit. Let's see what Judge Boyd is up to.
And 30 days for a PTD. It's actually set tomorrow. And defense attorney will get a signed reset form for you.
Yeah, that works.
On August 19th.
It should be dismissed and taken care of by then. I appreciate it, Judge.
All right, thank you.
Do you have anything? Oh, Norma's going to give.
Yes.
Thank you, Judge.
Isaac Chavez.
Paging Isaac.
Judge, this isn't on the docket today.
All right, is your client here?
It's right here.
All right.
In custody.
Sir, what's your name?
Nope.
Doug Campbell. Judge, we're here to ask for the court to set a bond and an MTR. Mr. Chavez was here on a couple of other items in another court, and while he was here, he decided he wanted to address the court and turn himself in.
Have you spoken to the state?
I have. They want 15,000, and that's a little bit more than my client can afford.
All right, we'll have to go on the record.
So he had some warrants. He's turning himself in.
Okay, thank you. All right, we're going to go on the record. Court is calling 2024 CR 1943, State of Texas versus Isaac Chavez. Could I have parties announced for the record for the state?
Jason Gearhead, Your Honor.
Defense?
Doug Campbell for Mr. Chavez.
And are you Isaac Chavez?
Yes, ma'am.
All right, state, have you had a chance to review defense's motion to set bond?
I haven't, but he brought it to my attention and I'm aware of it.
All right. And state, are you ready to proceed?
Yes, Your Honor.
All right, defense?
Judge, I'll call Mr. Chavez.
All right, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Isaac Chavez.
Isaac.
Defense, you have direct.
Thank you. Isaac, where do you work?
I work at a restaurant called Willie's on 1604.
And how much do you make an hour?
I work off tips, but I would say roughly $18 an hour.
And you're here today because you want to turn yourself in.
Excuse me, just a second. Guys, we're on the record. There's a sign. What does that sign say right below you?
It says, don't talk here.
Oh, sorry, Judge.
Yes. All right, we're back on the record.
Thank you,
Here's
Judge.
your sign.
You're here today because you understand you have a motion to revoke in this court. Is that correct?
Correct.
And it's because of some things that that you did outside of court, and you'd like an opportunity to address those out in the world.
Yes.
Do you think you can afford a $15,000 bond?
No, not at the moment.
Why not?
Just waiting for the budget, like my family and everything.
And to be fair, it looks like you've got an evading arrest with a vehicle that's coming up in this court. Is that correct?
Correct.
Do you believe that you're guilty of that?
No, I do not.
You also have a DWI in County Court 14. You understand that part of your program here for the deferred adjudication is that you're not supposed to be drinking, right?
I do.
And what steps are you going to take so that you don't drink alcohol if the court were to give you a bond?
All right, just a moment. Let's go off the record for a moment.
Whoa. Whoa. Why is she taking it off the record right now? I've never seen her do that. I think the lawyer's sort of jumping the gun, assuming he's going to get something that I don't think he's going to get. This is the spiciness that we need from Judge Boyd this morning. We are court hopping this morning. We'll be going live. Well, the Ashley Benefield trial, as soon as they see the jury, we're going to start covering that. But this afternoon, in about 2 hours and 10 minutes, we've got the Karen Reed hearing.
With that, Judge, I'll rest.
We're back on the record. And so you rest?
Yes.
All right.
Sir, you had a bond on this previous case that you're on probation for, is that correct? You had a bond of $10,000 previously? No. You don't recall that? No, I never had a bond. You pled to this case, right? Yes. Here. Previously, you had a bond on that case. Wait, yes. Okay, and did you make bond?
No, because I had two bonds. I had a remanded without a bond, and then I had.
I think we're missing a point there, but the fact is, you have family here in San Antonio?
Yes.
And mother, father?
I'm in contact with my mom.
Okay, but you do have other family members that live here in San Antonio?
Yes.
And have you spoken with them about any type of bonds that you could possibly make?
Yeah.
And are they going to be helping you with that?
They said they could try what they can.
Okay. No further questions, Joe.
Oh, anything else? All right, I just have a few questions related to the bond. Mr. Chavez?
Sure.
Have you ever received any type of mental health diagnosis for any
No.
mental health issues?
No.
Have you ever seen a psychiatrist?
No.
With regards to drug use, and I'm going to talk to you about drug use before you were placed on probation for legal reasons. So before you were placed on probation for this case, had you ever used drugs or alcohol before?
Yes, when I was 16.
All right. And what were you using when you were 16?
Just marijuana.
Okay. All right. So defense, what are you requesting in a bond amount?
We're asking for $1,000, Judge.
All right. State, what are you requesting?
State's requesting the previous bond was at 10,000, we're requesting 15,000 now.
All right. This is what the court is going to do. And I don't accept any of the allegations in the motion as true, but the court is aware based upon questions that you have an evading arrest and you have a DWI that's pending. The court is going to set your bond at $8,000. And I'm going to order full GPS. And I think the full GPS will take care of any concerns or issues. I'll ask that the fees be waived. Are there any no context orders that are needed, State?
I don't believe so, Your Honor.
And the court will note for the record that the defendant is currently on probation with the court, so the court is aware of any type of conditions that would need to be set on this bond. All right, that will be your bond, and we need a court date for this, Ms. Ferguson. It's 2024 CR 1943. And counsel, are you on the DWI as well as the evading?
Yes, Judge.
Okay. All right, it's going to be August 20th. And we'll set it as a contestant, but we'll see if you have all your discovery. All right, is there anything else?
No, Judge. Thank you.
All right, Deputy, if you'll make sure that he has his reset form before he leaves.
Yes.
Yeah, 2 a.m. That's pretty early. That's pretty early in the morning. Get some sleep. Thanks for watching from the other part of the world, though, the other side.
Oh, it's in there. I'm so sorry. Yeah.
Well, yeah, I guess it's sort of.
Robert Castillo.
Very good.
In, let's see here, where are we at? We're on, she's on 7, okay. In Judge Webster's court, let me just show you this. The guy in the warehouse is still there. He's still sitting there, still sitting in his boxes. He has not been addressed yet.
There was a video or something.
So, Judge, in this case, there was a USB drive that was found in the defendant's vehicle. Video was pulled from that USB drive and has been provided to the defense.
Okay.
The state had sent that USB off to an expert to see if they could forensically look at the USB and see if there's any additional video that could be inside that we just don't have access to. I did speak with our expert. He did say that he was complete with he completed his investigation. He sent me at least the Word document version of his report that I have had our paralegal upload to discovery, so the defense should have access to that after today. At this point, the expert said that his actual report is going to be on a USB drive that he's sending back to us because of how large it is. So I don't believe we received that back yet, but once we do get that report back with all of his findings, that's something that we'll hang over immediately to defense.
All right, and has he already actually sent it and you're just waiting to receive it?
My understanding, and again, I spoke to him on Thursday, is that he was going to send it out on Friday, next day mail. I haven't gotten word from our investigator that he's received the USB back, so I'm just unaware.
2 p.m. Eastern.
I can go and reach out to our investigator.
So he's already sent it. That's what I'm trying to get to.
That's what he told me on Thursday, that he was planning to do that on Friday, but I didn't confirm if he had sent it on.
Okay.
Judge, we've got a consulting expert, David Gallant, who is, it was our understanding when this got sent off that they were going to contact him and there was going to be some conversation about him getting access to that USB drive. But that USB drive, just to refresh your course memory, is essentially the hard drive for the Tesla.
Yes.
And so that's what we're talking about. And so we still have not seen the hard drive. And I don't know exactly how to do that other than, I guess, wait till it gets back and then we can try and have Mr. Gallant be able to access it either at the DA's office or someplace where they're feeling confident that it's not going to get tampered with or anything else. But we need to see the actual drive at
All
some
right, so
point.
I'm giving everybody a date, and because I don't think my instructions were, I'll take the blame that my instructions were not clear. I am going to give you all a date. And the date I'm going to give you, your expert can appear by Zoom. The person who is sending you the drive, the person who's supposed to get the information from the Tesla, he needs to be on by Zoom. Both parties agreed that their experts could appear by Zoom. So they're going to be here by Zoom. They're going to be on the screen. They're going to be in the breakout room talking to each other. And then this will be the last date that we're coming here for somebody needs something. So this case is going to be recalled, and it is going to be recalled for August 5th. If people want to, yes.
Judge, I got 2 kids going to college that week.
Okay.
And I am not
August 12th.
August 12th. I will make that happen.
All right. So
that means he's free.
everyone. So it is clear. August 12th, your experts, whoever it is, need to be available by Zoom. They're going to go in a breakout room and they're going to discuss, and counsels, if you all want to be in the breakout room with your experts, you can be in the breakout room with your experts, but they are going to discuss what is there, what is not there. And this is the last date that I am giving for us to have, I say us, but for you all to have everything as it relates to the Tesla.
And Judge, my understanding just from speaking to our expert, the report, it's going to be in essence, if you compared it sort of to the program, if you look through someone's cell phone. So it's going to be something that it's going to have access, it should have access to everything else that was in that USB drive. It's just that he forensically mapped it on to another drive.
Okay.
So if beforehand, if we're able to get that to defense, that may solve a lot.
It's not going to, I don't think it's going to solve it because we've been trying to solve this for a while now. So I want to be clear. Both parties' experts need to be here by Zoom. They can go in a breakout room. They can talk it out together. That's what's going to happen. And then you're going to get a trial date. And your trial date is going to be the same date as your plea deadline date. And if you want to come in and you all have entered an agreement before the trial date, you're more than welcome to do so. But this is the last day that we're having something on this discovery about information from the Tesla.
Can I ask the court one favor?
Sure.
I'm literally driving back from Missouri on the 11th. Is there any way we could do this on the 15th? I've got to be in here on Jose Cavazos for a ruling on Article 64 anyways. Would that be possible?
He said he would make it work.
Thank you so much, Judge. I really appreciate that.
Sure.
You said he could make it work. And then
David McLean, McLean. Thank you.
Number Robert Castillo is August the 15th. And Norma, if you'll make sure both of them have the Zoom link, I know the state will have it, but make sure everybody has the Zoom link so that their expert can Zoom in. All right, let me see. Gabriella Rubincheck?
Excuse you. Thank you.
Yes, your excuse.
Yeah, she called the new case, so you can probably leave. Interesting, the Tesla case. We'll have to keep an eye out for that one. Welcome, I Want My MTV. Love the name. There's a song that goes with that. I bet you probably know that. Let's see. Someone was asking, what does it mean about take your reserved seat on the front row? When somebody types ! seat, if they're a member, meaning their name is green on the channel, then I
All right,
respond
so she has
welcoming
some
them
cases out
because
of
members have reserved seating.
another
It's all
county?
just virtual. It's a virtual
She
perk.
has one case up in Dallas?
McKinney?
McKinney, I'm sorry.
Is she in custody or is that?
All right.
I can't tell if she's in
So on
custody or
this case, she has the cases out of county. What I can tell you is the cases out of county, because they are open cases, if I were to place you in a program, they're not going to be able to accept you because you're out of county. So we're going to go on the record. Court is calling 2024 CR 0736, State of Texas versus Gabriella Rubincheck. Could I have parties announced for the record for the state?
Andrew Harris Edelman.
Defense.
Robert Barron for Mr. Rubencheck.
And are you Miss Rubincheck?
Yes.
All right, you entered a plea,
Yes, I did.
and according to the plea bargain agreement, the state is recommending deferred adjudication. All right, could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Gabriella Rubincheck.
All right, and when are you due?
I am due October 26th.
I guess congratulations.
And if you were released, where would you be residing? In what county?
Here, San Antonio, Bexar County.
And do you have any family here?
Yes, I do.
Who's here for your support?
I have both of my sisters
We got Baker
and
acted.
a lot of my cousins, my dad.
All right, how many children do you have?
Welcome, Broken Bakers.
This will be
and
my third.
clan.
All right. And so your other two children, where are they?
They right now are currently with my first, their dad's family. So with their grandparents, but on the dad's side. And then I also have my baby's dad here for support.
All right. And
Parenting classes.
your two other children, were your rights terminated?
I did have an open CPS case. I did successfully complete drug court, and I got my parental rights back.
All right. So why are the children, other than you being in custody, is that the only reason why the children are with him?
Because I have to go back to court to open, I guess, the case. They told me, so they had originally granted PMT with PCA, which means that they were going to be
Oh, I know what it means.
She knows.
temporarily placed. I have to go, I haven't had a chance to go back to court to reopen it so they can be relocated back with me.
All right. And what are the ages of your two older children?
My son is 9. He just turned 9 July 1st, and my daughter is 7.
And when's the last time you've seen them?
Not too long ago, probably like maybe like 2 months ago.
That's a long time ago.
And have you had any type of employment before?
That's
Yes.
a long time for
Doing
the
what?
kids.
I was a server downtown on the Riverwalk at Landry Seafood.
Okay. Just as a side note, they need to step up their game on their gumbo. I'm just saying.
Yes, I agree.
Thank
I
you.
totally agree.
All right. And any drug use?
No.
Ever?
Previously, but I got over
All right. And what previously was it?
meth, amphetamine.
Okay.
She got over it on her
And how
own.
far did you go in school?
I only need 1 credit left, and the only reason I did not get that credit is because my daughter had gotten an upper respiratory virus called the rhinovirus, and she had to stay in the hospital for about close to 2 weeks. I was going to a self-paced school, so I ended up taking all the little bit of work that I needed to finish to complete that last credit. But by the time we were both, or she was released and we could go back to school and she could go back to daycare, they withdrew me because of my age.
Okay.
But I do
can be
plan
done.
on going
It's
back to
just
school,
hard.
and I was doing dual credit, so I do have some college credits as well.
Okay. So what's your dream job? What's your plan for your life?
To be completely honest, to continue going to school, to get my diploma since I only need 1 credit, and then to continue my schooling, to become a surgical nurse, and then eventually an anesthesiologist.
Okay. All right, with these cases, it's going to be difficult to do those things because anytime you have a type of employment that requires a license, they do background checks extensively. And there are some charges where you're going to have difficult time obtaining your license.
For
But it's
trustworthy
not
issues.
impossible. No, it is not. All right. Any questions from either side?
Judge, I just want to reiterate, I did speak to Collin County Jail. They verified that her case is pending, that the bail is set at $10,000. And the woman I spoke to said that they would come pick her up once a 10-day pickup notice was received from the sheriff.
All right. All right, the court is going to sentence you to a $500 fine. That will be probated and state you're excused.
Thank you, Your Honor.
Court is going to sentence you to 4 years deferred adjudication.
She doesn't know what that means.
There is going to be regular reporting by Zoom or in person.
Parenting classes.
I'm going to want the UA hotline until further notice. Proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. 200 hours of community service restitution. 100 hours of those will be waived once she obtains her GED or higher level of education. The remaining 100 hours will be waived once she completes parenting classes.
There were those parenting classes. We knew those were coming.
And upon return from, what county is it?
Collin.
Sorry?
Collin. COLLIN.
All right, return from Collin County because they're going to pick you up from the jail. She's to report to court upon return from the county. So if you come back on a Monday, you need to come to court. You understand? Yes. And I'm going to want field visits 1 time per month for 6 months. And we'll do a TAP evaluation and referral to felony drug court upon return from Collin County. And CPS compliance, if applicable. Probation, is there anything else?
I apologize, I can't hear you on the county meeting.
Collin, COLLIN. All right, is there anything else you need from the court to be successful?
So I do the tape. You wanted the tape evaluation done.
The TAP evaluation, what's going to happen? I don't want that to hold you up from going to Collin County.
Okay.
So what ends up happening is they're going to put it in the system, a release for you to go to Collin County. When Collin County finishes what they're finishing, whatever they're doing with their cases, you have to come back here to Bexar County to this court. Do you understand?
Yes.
So immediately upon your release from Collin County, when you drive back or somebody picks you up and you go home, next business day, you need to report to this court. Do you understand?
Yes, Your Honor.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? And did you understand it?
Believe so, yes, Your Honor.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing in this court, to be successful, communication is key. Talk to your probation officer. When you get released from Collin County, if there's some issue with you coming back immediately to Bear County, pick up the phone, talk to probation. If you feel as though probation is not addressing it, come back to court.
Okay.
But remember, in your mind, when you get released from jail in Collin County, you need to come back to the 187th in person. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Thank you.
You're welcome.
Judge,
Mr. Attorney, I didn't hear your name.
Robert Behrens.
Barron's, B.
Abel Favala.
RENS.
Thank you.
Who's here on Abel Favala? Hi, come down.
The next contestant. Just so you know, we have a thumbnail up for the Karen Reed trial date hearing, which is starting at 2 o'clock.
Where are we on this case?
1:30. So we're
Yes,
gonna take
Judge,
a lunch
I believe
in about
discovery
15
is
minutes.
intact at this point. My client wishes to assert his constitutionally protected right to a jury trial in this matter.
Okay, State, did you make an offer?
Yes, Judge, we made an offer today.
Okay,
And the defense counsel has rejected it.
okay.
We've rejected it. We want a jury.
All right, Mr. Favala, do you need a chance to consider the state's offer or no?
No.
No? All right, then I'm going to need a discovery acknowledgement from each of you before you leave today, counsel.
Yes, Your Honor.
And State, how long do you expect this trial?
A day, Judge, 2 days, it'll be quick.
All right, Ms. Ferguson, criminal trial division, need a jury trial date. It will be quick.
There it is. It'll be quick.
Need a jury trial date on Favala.
So what's happening right now? Ashley Benefield, the Black Swan ballerina trial. We might know it by a couple different names. They're in jury selection right now. We're awaiting word to see if they're able to seat a jury out of the panel of 70 jurors that they have.
October
before
1st, you'll be brought
right
over
now.
dressed for trial in whatever clothing you have at the jail. If you wish to be attired into something different, you'll need to do a clothing exchange with your attorney. Counsel, if there's an issue with the clothing exchange, let the court know and we'll see if we can help expedite that.
Very well, Judge. Thank you.
All right, thank you. Is there anything else?
This attorney's like, don't.
You have reviewed the case in hand, right?
No. This is what I'll tell you. Sometimes people get confused on what I know.
Yeah.
The only thing I know about your case is what it says in the indictment. I don't see any evidence unless evidence is at some stage presented to me. So all I know is that you're charged with an aggravated assault with a deadly weapon. I don't know if there's witnesses. I don't know if there's video. I don't know any of this. Okay.
Ag
All
assault
right,
with a
thank
deadly
you.
weapon. That's no
Ms.
small
Nadia, Are you
charge.
filling in for Ms. Lemerson?
Lindsay Hernandez. Who's the attorney for Lindsay Hernandez?
I am, Your Honor.
Oh.
Yes, convenient enough.
Okay.
So Jacqueline Anderson was the interim chief public defender.
As they're coming up, we'll be taking a lunch break and then jumping to the Karen Reed new trial date hearing live after
Hello.
lunch.
All right. So today is plea deadline date
Correct, Judge. Yes.
and
Did receive an offer from the states. Client is not in agreement with the offer. We would again wish to assert her right to a jury trial in this matter.
all right. So what that means is your plea deadline date has expired. The court will not consider any plea bargain agreements without good cause. Otherwise, you have to plead open to the court. So you're telling the court you wish to go to a jury trial. Is that correct?
Yes, ma'am.
All right. State, how long do you expect this jury trial to last with Ms. Hernandez?
2 to 3 days, Judge.
2 to 3 days?
There are a few witnesses.
All right, Norma, 2 days on Lindsay Hernandez? Yes. All right, we'll be back on October 1st. And you'll be brought over dressed in whatever clothing you have at the jail. If you wish to be attired in something different, you'll need to do a clothing exchange with your attorney. Do you understand?
Yes, ma'am.
All
Jennifer,
right.
Jennifer, if I didn't
Your Honor,
ever
would you
give
like
the
a
internet,
acknowledgement on that as well?
Yes, please.
congratulations. Thank you for being first in chat. As we wrap up here just for a minute, I think we'll take 1 or 2 more cases from Judge Boyd. Then we're going to take a lunch break. It'll be about 1 hour. We're going to come back with the Karen Reed trial as that's going to kick off here soon up there near Canton. It's gonna be interesting. This is one that's, there's a lot going into this, and lots of things can happen. So which direction this goes will be quite compelling. In the Ashley Benefield trial, we're going to return to that one as soon as the jury is seated. They're not showing jury selection right now, so we won't know. We'll just have to watch social media, and for those who are down there in the courtroom, to let us know when that happens. But it probably will not begin today. It probably will begin either Tuesday or Wednesday. Have a meeting at 1:30 to 2:30. Oh man, Karina, is it too soon to start faking a cough or something? Because there's like a sickness coming on that you might, out of the kindness of your heart, not want to spread to your coworkers that you could get out of. By the way, yes, we did hit a new high on our membership number. We're up to 59,117. Thank you for those who have just joined the channel. We're glad you're here. We're glad you're here, and we won't let you leave, though. That's the way it is. It's a one-way door. You live here now, and we love it. We love it. So welcome. If you have questions, we have the most amazing mods that will help out, as well as I'll try to answer any questions. If you have one for me, please don't think that I'm ignoring you. I'm not. Just try to tag me in chat. I can't answer all the questions, but I'll try to answer the ones that I can. Sometimes I get asked questions in chat that might be more appropriate on just a direct message. And lucky for you, I have a burner phone where you can reach out to me directly via text message is preferred, and I'll try to respond to those messages. But the burner phone number you'll see periodically in chat, 801-513-1160, I think it is. I haven't called that in a long time, but digital string there. Thank you very much. We'll have to keep this in the corner and see what happens. All right. What we're going to do, we're probably going to take just a little bit longer than an hour lunch, if that's all right. Give everybody a lot of time to reset and get ready for the Karen Reed trial, which will be starting at 2. At least, I say it's retrial, but this is the hearing, the Karen Reed hearing, about whether or not the state is going to go forward, or how they're going to go forward, or when they're going to go forward with a new trial. She was... we had a hung jury last time that was a mistrial. How that went down is all in question. Well, it's not in question by the state. It's in question by the defense. They want to change really the record on what happened there, trying to get information into the judge to say, look, the jury agreed on 2 of the charges, 1 and 3, that she was not guilty. So we need that, going forward. Otherwise, it'll be double jeopardy attached. So, yeah, we'll see. It is like Hotel California here for sure. We're excited for 60K. Apparently, Kasha has a big party, balloons, everything planned for 60K. So that's going to be exciting when that happens. Karina, unfortunately, on the replay crew, it's probably better that you keep your job, Karina. I appreciate you doing the important things. There's the burner phone number. Make sure you save that if you ever need me, or if you see something happening in the world of true crime that you think I need to know about. That's a quick way to get it. If you... For some of you, I know some of you record court as it happens, especially some of the courts that are no longer available as soon as they stop happening. For those who are trying to get me a copy of something that happened in court to review, I have a WeTransfer account where I think I pay for like 2 terabytes of storage, and you can send me something. Let's see if I can get it to pull up. It's under my Topmark Media channel, so it's Topmark, TOPMARK.WeTransfer.com, and you can send files over there if you need to send large documents or things like that. Angela, still no solutions for international callers. I'm about to get like a physical burner phone for the channel. That's my thought. A physical burner phone, new phone number, and then probably what's the app? WhatsApp. That's my thought. That's how it's probably going to go. All right. Big Sky DMC says, all new to this channel, RA is great about getting back to you if you reach out on the burner. Best in the business. I try, but I will tell you, there was a point where I said I'll reply to every message. I can't do that anymore. There are times that I'll get 50 or 60 messages in a day, and I just, it's tough, but I do definitely try. Sometimes I stay up late at night, and if you get a text at like 2 o'clock in the morning, that's me trying to catch up to all the Messages. Well, we got a few more there. We're up to 59,125. Thank you. I think that was digital string theory, connecting all his other accounts. I appreciate that. All right, there you go. It was already subscribed on a few, but you added a few more. There it was. We saw it happen. So appreciate that. All right. As we go to break here, as we go to lunch, first of all, I hope you have some great lunch planned. I have a salad. But sadly, I don't have any avocado. So I need to get some avocado. And but I'm looking forward to my salad. It's going to do, I can tell you about it if you want, but it's yummy. I've been looking forward to the salad all morning. It's part of my diet, which I am loving. I'm feeling better than I've ever felt, honestly. I'm down nearly 20 pounds. That sounds good to say. That sounds awesome. Anyway, I'm excited. I've got a long way to go, though. So wonderful. Ella Cole, he's never managed to message me back, even during dire circumstances. Ella, you're international, aren't you? It won't let me message back internationally. Send me an email, maybe? That'll work as well. Get a sleep study. Oh, last night would have been terrible for a sleep study. I slept like a baby all night long, like 9.5 hours. It was great. All right. Yes, we are coming up to, I call it my family vacation. You needed help. Reach out to me again. I'll try. Maybe on email. Oh, you're joking? All right. Okay. We've got a vacation coming up. It's a working vacation for me. I'm going on the road. We'll be going to the Corey Richens trial in Utah, in Park City. We'll be attending that in person. Going to meet Danny on direct out there. We'll also might be eyeing what's going to be happening in the BK coming up, and all that. So anyway, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again in about an hour and 8 minutes. This will be with the Karen Reed new trial date hearing, and we'll be live with that. You guys, we'll see you after lunch. Have a good one. Bye-bye.